Good afternoon, everyone. We're going to call the Board of Adjustment to order. First, let me announce all the decisions of this board are final. If there's anyone aggrieved by the decision of this board, they may appeal to circuit court within 15 days of the board's decision. Also, no permits or license can be issued until that 15-day appeal period has expired. For information regarding our decision today, you can contact the Office of Land Use Administration. For information regarding the decision, if you will, wait till after the meeting to contact them if you have any questions. I would ask that if you've got an electronic device that you silence it or turn it off at this time. And as we conduct a meeting, I will be, based on the audience, having to stick to the strict rules regarding the time and the number of individuals speaking. The normal time period is 5 minutes, and there will be 4 individuals either in favor of an application or for opposition. So pick your best 4 before we get started. So we'll have no delays in determining who's going to speak. Also, we want to make sure that you direct comments or questions to me as the chair or to the board, not others in the audience. And if you will, please keep your kind of sidebar discussions to a minimum so we don't have any disruptions. All right, first let me call the attendance. Mr. Davis? Here. Mr. Coleman? Here. Mr. Metcalf? Here. Mr. Burrows? Here. Mr. Milling? Here. Mr. Golden? Here. And I'm William Guest. We have 7 members present. It takes 5 to affirm a motion or to deny, depending on the motion. And we have a quorum, so therefore we can conduct a meeting. We have Mr. Minus here for the first couple of the applications that we're going to have today, and then Mr. Anderson, who's the normal attorney, should be here at a later time. Also, I want to just ask, and I pretty much know the answer, but I'm going to do it for the sake of formality. How many of you are here for case 6223, 62-4? Both of them are 2955, 2989 Dolph Street. Raise your hand, please. The Dolph Street. Okay, okay. Well, we'll start with, both of these are regarding Mr. Myers, right? Okay. So we're going to go out of order based on the number present so that we can get that out of the way, and then we'll go to the normal order of the meeting. Okay. All right. Well, we're going to hear application 6223. Mr. Myers first. If you'll come to the podium, please. So we'll go out of order, and I appreciate your patience. And then 6224. Your name and address for the record, sir?
Yes, my name's Casey Pipes. I'm an attorney at Helmsing Leach representing Mr. Myers. And are we just talking about the administrative appeal one first, or do you want me to lump them together? However you want.
Well, actually, I'll probably help with some of this. And you help me clarify, and I've got Mr. Minus if I've got any questions. In the application first, that's 6223, you're asking for administrative appeal for a decision that was submitted to initial planning commission, and then the appeal was filed with the city council, correct?
We're asking for an administrative appeal of Ms. Pappas' zoning interpretation, which she gave us, it's in the application, but a couple of months ago. Well,
based on the review of the letter, her response to you, that it does not appear to be an administrative decision. From my understanding, and I'll defer to Mr. Minus, that was a decision that was made by the city council, which this board does not have authority to hear appeals. You have a normal appeal period that would be through circuit court, I believe, for city council decisions. Is that correct?
In my point is that Mr. Myers, along with everybody, is entitled to an interpretation of the zoning code by a zoning official, and we never got that through the course of the planning commission process on the PUD. We went in there for a driveway approval, essentially, and came away with a zoning interpretation by the planning commission, not by the staff and not by Ms. Pappas, but when Mr. Rossler addressed the Planning Commission, it was his recommendation that the use be limited. The Planning Commission made that rule, but we never got a staff zoning official's interpretation of that. And even when it went to the City Council doesn't interpret its ordinance and give us a ruling on how to interpret the ordinance. They enact the ordinance, but they don't interpret it. There's a very specific role the zoning official has, and then this board has a very specific role, and nobody can usurp y'all's authority to hear appeal from that zoning administrative opinion. We ask for what is the zoning classification for this property? We think B2. Mr. Donald Stewart, who you'll hear from later, has written you a letter. He thinks it's R1. Jim Rossler thought it was B2, but limited to a bank and a drugstore. I'm not even really sure what Wanda Cochran thought it was when it went to the City Council. We were entitled to an opinion, and we got one. We disagree with her opinion, and that's the role of this board.
Well, I don't necessarily agree with the administrative appeal. I do agree that you have the right to a use variance, which we, based on the authority of this board, will hear either today or at some point, based on the decisions of this board. Mr. Minus, any comments regarding the administrative appeal?
You correctly stated earlier that there hadn't been no administrative decision. The response to Mr. Pipe's letter was just he asked for what it was zoned for, simply stated what had already been determined by the Planning Commission and by the Circuit Council of the City of Mobile. Even if Mr. Pipes is correct, I don't think there's been an appropriate request for a determination by the staff other than he asked what was it zoned for. And I don't think that gives rise for jurisdiction of this board to review that determination.
Okay. Sir, I don't think today that this board, with me as chair, that I'll request that we consider that particular appeal, administrative appeal review. But your next application, which is 6224, which is as a use variance, I do believe and I agree that that's within the authority of this board. So we will not hear the first application or appeal, administrative appeal, but we will hear your use variance request.
And I'd like it noted that that is against my druthers and request. I would like a ruling on both, but I understand what you've said, Mr. Chairman.
Yes. Okay, this application is 6224, 2955, 2989 Dolphin Street. It's for the use variance to allow a car wash in the B2 Neighborhood Business District. The site was rezoned B2 Neighborhood Business District via Ordinance 64-049, which had been construed to limit the use to a drugstore and a bank. This particular application has been recommended for denial. Will you tell us why you think otherwise?
Yes, thank you. Again, Casey Pipes, Helmsing Leach representing Mr. Myers. This isn't your typical variance request. Normally a variance is our lot's too narrow, we can't meet the side yard setback, our lot's too shallow, we can't meet the front yard setback, one of those things. This variance request arises from an unnecessary hardship imposed by the city, not because of the land itself, but by the actions of the city here. Mr. Myers was looking for a place to build a car wash. Property was available for sale, represented as being B2. He goes in, gets it under contract for $675,000 back in 2016, subject to doing his land use and zoning due diligence. And he applies for a PUD to build a car wash, very specifically a car wash, not some commercial use of undetermined origin or vintage, but this car wash on lot 2. And he needed the PUD because he was trying to work the access to Dolphin and Sage, and it was multiple lots sharing one driveway. The staff recommended approval. Planning Commission approved it. No one mentioned that the land was limited to a bank or to a drugstore. No one mentioned that you can't put a car wash here. No one stopped him from doing anything. Everybody proceeded just as it shows on the zoning map of the city, B2, just as it says in the zone ordinance for this property that was passed in 2008, Ordinance 64-049, which rezoned the property to B2. It said any use, any structure allowed in B2. Now, it said limited to an approved PUD, but it did not say limited to this particular PUD or to this particular use that's shown on this particular PUD. There was no voluntary use restriction imposed by the applicant with that application in 08 that limited it to a bank or a drugstore. So when Mr. Myers' application came through in 2016, it was approved and it was allowed. He then closes on the purchase, buys it for $675,000. They run into a problem with some trees that they didn't think were on the site that were impacted by the road. It delayed the project. They tried to get a tweak to the road. It didn't start work, and so that 2016 PUD lapsed. They came back a few months after it lapsed with this 2018 PUD application, which showed the same car wash but a different road to avoid the trees. Now, this 2018 application is when the Planning Commission took the position that a car wash wasn't even a permitted use. So the PUD was denied. It put a car wash on Lot 2. Now, no laws had been changed in the interim, no ordinances had been changed, no Planning Commission regulations or city regulations had been changed in that time period. The only thing that changed is that Rob now owned the lot instead of Hancock or Whitney Bank owning it. And the staff work on that PUD application couldn't use it as a car wash. This was something that came up live at the Planning Commission hearing based on an interpretation by a lawyer for the city, for the Planning Commission, that said that a court may find, if it was challenged, that this ordinance wouldn't allow that use. Now, Rob relied on the city's approval in 16. He relied on the city's ordinance. He relied on everything else. It is manifestly unjust and unfair to stick him with this lot downzoned after the fact when no ordinance has changed. And there is a variance procedure that this board has the authority to do to avoid unnecessary hardship. Unnecessary hardship here is that he has over $675,000 stuck in a piece of property that is essentially worthless. If you limit it to a bank or a drugstore, he's not a banker, he's not a drugstore developer, and no one's going to put one in there. And so that's the variance request, Mr. Chairman. And Mr. Stewart, and I'm not sure if the bell means I'm out of time or if I have another minute. Okay, sorry. Mr. Stewart takes the position in the letter that he wrote to you that we're not entitled to a variance, but our remedy is to sue the city, and we're trying to give everybody an opportunity to avoid that outcome. Thank you.
Okay. Any questions of the board's representative?
Mr. Chairman?
Yes, Mr. Metcalf.
Casey, is it, would it be a fair statement to say that had the 2016 PUD had not expired and they had gotten an extension of that we would not be here today?
The 2016 PUD, we had to change the driveway to avoid a tree. But yeah, I think it's safe to say,
couldn't that have been done
Oh, yeah.
under the same PUD application?
It could have probably been handled as an administrative adjustment to that driveway.
Right.
And
So
we wouldn't
basically
have
it
been here.
expired.
Yes.
Okay, so it's although there's a lot that has happened up to this point, but that PUD and approval is gone.
It did. It's gone.
It's gone. Okay, so we're really starting fresh from one aspect. Secondly, if you contend that the property is zone B2, I'm not saying it is or isn't, but if you contend that it is, then if you're coming in for a use variance, are you not affirming that you think that it's not?
Well, when we originally submitted the application, we had an administrative appeal of the decision by Ms. Pappas that it was zoned B2 but limited to a
I'm
bank
talking about
drugstore.
the next application coming up.
When we had an alternative, we thought they were going to go together today. We had an alternative request that if the commission did not grant that administrative appeal, we had the variance request saying, even though it's presumably, I mean, at this point, we would normally be at it's zone B2 but limited to a bank or drugstore, and we're trying to get a variance to allow B2 but allow a car wash, which was what was represented when he bought this property and got into this position, which he wouldn't have gotten into if he'd have known this was the city's interpretation.
Okay, thank you.
Thank you.
Okay, any further questions?
Yes, sir, Mr. Chairman.
Okay, Mr.
And
Miller.
Casey, it's y'all's position that in 2016, when the PUD was approved, it was open and clear that he was putting a car wash there, it was properly noticed, and that it was approved without any limitation as far as on the B2 use. Is that correct?
That's correct. It was site plan specific. It showed the car wash, it showed the tunnel, it showed the vacuuming stations, it had the number of vacuums. You know, it had all the information that made it clear to the staff and the public that we were talking about putting a car wash on Lot 2.
Do you know at that time, was there any opposition to it?
I was not involved at that time, but my understanding is there was none.
Okay.
But I
Right.
was not here.
Understand. Thanks.
I have a question. Was, when the request was sent out, because you had to go back based on the timeframe, the expiration of the PUD, was there a proper notice, an issue with the notice?
In 2018,
Yes, go ahead, proceed.
Okay. When the PUD came up this year, at the initial hearing with the Planning Commission, one of the Planning Commission members specifically asked if there was an issue with the notice on the rezoning when the applications were initially submitted in 2008, specifically citing the Roadhouse Grill case that the City of Mobile was involved in. The 2018 PD, in May of this year, it was then held over. That issue was researched, and it was found that when the notices for the rezoning of the overall site, as shown here, let me see, which is approximately 8 acres. That is when it came in for rezoning from R1. There were a couple of holdovers to alter the rezonings requested at that time, but it ended up the final rezoning notices that went out to the neighboring property owners stated rezoning from R1 to B2 for a bank and drugstore, LB2 for limited neighborhood business for unspecified uses, and then the R3 back here. So the question of notice was associated with the rezoning applications in 2008.
Okay. Well, we have multiple online comments, and then you've had written comments as well, upwards of 85, 90. I mean, it seems like there's a substantial number that have come in since, I guess, which is to address Mr. Milling's question. Have you seen those as well?
no, I'm not given access to the online comments. I've seen a letter from Mr. Stewart,
Okay.
which was submitted to the board.
All right. Any other questions for the applicant's rep? All right.
Thank you.
Is there anyone here besides yourself to speak on behalf of this
No.
application?
No, thank you
Okay.
for your consideration.
All right, thank you. All right, anyone in opposition, if you will, pick 4, and we'll start in whatever order you wish.
afternoon.
Good afternoon.
My name is Don Stewart. I live at 121 Fraser Court in District 1. I'm the lawyer for over 24 folks who live near the property that's involved in this discussion. Many of them have come off from work, and I'd like them to show their hands so that they can be recognized as being here and being interested. They're very interested. If I lined all those folks up and asked them to talk to you about how they feel about this project, they would all tell you exactly the same thing, I think, wording a little different. They tell you in no uncertain terms that allowing a car wash with 36 vacuum stalls operating 365 days a year at this site would be a profoundly bad idea, and from the standpoint of land use and planning. But my job is not to carry that message for them today, because the issues that y'all are looking at, and I think you've gotten pretty quickly to understand that, are legal, and they do not get to the issue of the merits of the car wash or not. As a matter of law, and I think you've correctly already disposed of it, they have appeal right, because you cannot appeal to this board under the statute from a determination by the Planning Commission and the City Council. The issue of the variance, however, is one that we need to talk about a little bit more. There is also I think, clear legal problem with what they're asking for. It is a given, and what you have to work with is the conclusion that the Planning Commission made and the City Council made that says, in very clear language, the use as a car wash is not allowed by the rezoning ordinance. This was adopted by the Planning Commission on the advice of the legal department of the city. It was affirmed by the council on the advice of their lawyers. So there are plenty of lawyers weighing in here. What he wants is essentially relief from that determination on the rubric of a use variance. And it's interesting, he puts 5.5 pages or so into arguing why the Planning Commission was wrong, 1.5 pages for the alternative request for use variance. You folks look at use variances all the time and are very familiar with the requirements. It is a high threshold for a use variance. You must show unnecessary hardship. Essentially, for a use variance, you have to show inability to use the property as currently zoned. He's fairly forthcoming. His only argument is he paid $675,000 for a piece of property that he thought he could put a car wash on, and that he theoretically would suffer commercial economic loss if he were not allowed to put his car wash on there. Economic loss is not a basis for a use variance. The law is very, very clean. The ordinance, the zoning ordinance says that specifically. The case law that we cite to you says the same thing. Economic loss, commercial advantage is not a basis for a use variance. In addition, he is simply telling you, based on no presentation whatsoever, that the property is worthless. He's made no showing that the property cannot be used. We say for residential purposes. Other folks say for a B2 purpose or for a bank. He's made no showing of that at all. He just says, I run car washes, and therefore I want to run a car wash, and therefore it is I have an economic loss. He doesn't have an economic loss, even if he had an economic loss. As a matter of law, that's not a standard for a use variance. Now, in perfect fairness to Mr. Myers, he may or may not have been misled by what the city and the Planning Commission did or didn't do in the past, as he claims. And he may or may not have a claim for damages against the city or the Planning Commission or both under the facts. But as a matter of law, that does not translate into an entitlement to a use variance. He has a monetary claim if he's been done wrong by the city, but the relief that he gets is not at the expense of the neighbors and the zoning law. He cannot get a spot zone to solve anybody's problem.
I think your time's expired. Can you
Thank you.
summarize? Thank you. You have 30 seconds, sir. I just want to let you know.
That's fine.
Okay. All right. Any questions before Mr. Stewart? Any questions of the board? All right. Next individual wish to speak in opposition to the application?
Hi, letting me speak today.
Name and address, sir.
Yes, my name is Frankie Little, and I recently purchased a house at 2888 Lurondo Drive North in the Cromwell neighborhood. And so, yeah, I mean, I purchased this house about a month ago. When we purchased the house, we were of the understanding, the perception, that that property was not going to be a car wash. That had already been established. So I purchased this house for me, my wife, and our 2 children. You can, where that little corner juts into where it's purple right there, that's our backyard. We live on, yep, right there, exactly. That is our backyard. So essentially this would be, you know, in our backyard. You've heard all the issues with noise pollution, light pollution, traffic. But I would like to say that, you know, this is creating a hardship for many people, not just one person, if he is allowed to put the car wash there. Like I said, we purchased this house with the assumption that it was not going to be a car wash. We invested our money, and now we are looking, if he's allowed to do this, we're looking at a financial and emotional hardship. The land itself would not suffer a hardship to not be a car wash. We, the people in this neighborhood, will suffer a hardship, and I think that is important. And like I said, it's a large group of people that will be affected, and not just the people who live in this neighborhood, the city at large, I think, the traffic issue, for sure. You know, I think a car wash is a want, not a need. I'd like to say that. People need financial institutions, they need food, they need water, they even need pharmacies. They don't need a car wash. And I would like to point out that a car wash does not stand the test of time. I'm sure you all drive around the city. Every day you probably drive past a dilapidated car wash, one in disrepair. I'm not saying that's going to be his, but, you know, in my experience, you know, it doesn't last a generation. You know, 10 years from now, we'll have an eyesore at the corner of Dolphin and Sage. And I think, you know, that's not something anybody would want. So that's all I got to say.
All right, thank you.
Thank you.
Any questions?
I have
Yes.
a question, Chairman.
Oh,
Yes.
you have a question? I'm sorry.
Yeah. As far as your statement about that you were assured that it wasn't going to be a car wash, what steps did you take to get that assurance, and who gave you that assurance?
Well, our real estate agent, and among other people, and just reading the articles in the paper. I mean, I have to admit, I mean, I didn't have a lawyer scan over every piece of information about this issue, but through our research online and reading articles and you know, just being told by people on the know, it was a done deal. And it was literally a week after we signed the papers on the house that this meeting came up and this all resurfaced. So it was almost immediate that we found out that that was changing. So.
Any further questions?
Any other questions?
All right, thank you again.
All right, thank you.
All right. Next, please. Good afternoon. Your name and address, please.
Good afternoon. My name is Helena Roldan. I live at 2869 Hilburn Drive, which is the property facing the car wash property, and the Littles are my back door neighbors. So I am too on the corner and would be looking at the car wash. Okay, I purchased my property in 2008 with the understanding that that whole chunk of property, the beautiful Graff Dairy property, was zoned residential. Immediately after I purchased my property, that change happened where it changed, where my understanding was it was changed to be too limited to a bank or a drugstore. I'd like to say we're at, or I'm speaking for myself, but I also think I have my neighbors' support in saying we're not opposed to development on that property. We want neighborhood-friendly, quiet businesses on that property. We have a wonderful, we worked really hard to bring our neighborhood into the quiet neighborhood, child-friendly place that it is. And so while Mr. Stewart very eloquently spoke about the legalities of the issues, of course, we're here on the passionate side of the issues. We love our homes. We love our neighborhood. We want you to do the right thing and stay with whatever proper zoning is, but not car wash. Neighborhood-friendly development only. That's what we are asking for. And I'd like to end by asking you, if Mr. Myers bought the property immediately behind your house, do you want a car wash in your backyard, literally? Do you want the right to be heard about the car wash in your backyard? Do you want 36 vacuum stalls running at 8 a.m. on Sunday morning in your backyard? I would suggest that the answer is no, you wouldn't either. So I ask that you do the right thing. And we've got tons of neighbors to support our cause. This is just the little showing of the people who could get off work. Tons of neighbors couldn't get off work, and they would be here as well. Thank you.
Okay, thank you. Any questions?
I do, Mr. Chairman. So you said you moved in right before 2008,
I
or
bought
right
my
around 2000?
property the day the stock market crashed in October of 2008. I remember it clearly.
I guess the question I have is the same one I posed to Mr. Pipes regarding the notice in 2016. Because I guess what I'm trying to figure out is, regardless of not regardless, but, it seems there's obviously a big issue. Mr. Myers, went through the necessary due diligence steps that he thought, were required in order to satisfy himself to buying the property, that it was zoned correctly for what he wanted to use it for. Mr. Pipes said, or his attorney said that in 2016 he had an application that went to the city, and I'm assuming that it was properly noticed at that point, and from what he said is that it was clear of what the use was. Is that, from y'all's perspective, is that not the case? Did you not get notification?
I can speak about my experience. I promise you, it did not come to my awareness that it was a car wash proposal in 2016. As soon as I and many of my neighbor friends this year, when it rose the occasion of our attention, as we immediately galvanized and we flooded the Planning Commission. We did a social media campaign. We all showed up to the city council. When it was not on my radar in 2016. Whether it was noticed or not, I don't know. It was not on my radar. As soon as we found out this year, we haven't stopped since. And we will continue, I promise, to take it as far as we need to. We will preserve our neighborhood.
Thank you. Any other questions?
Yeah, Mr. Chairman?
Yes, Mr. Metcalf.
Just to piggyback on Mr. Milling, you said it wasn't on your car. Did you know nothing about anything in 2016?
I personally did not know anything in 2016.
But you're within 300 feet, so you got a notice.
I did not know anything. I may have got, I don't know. I can tell you it did not rise to my awareness.
Okay, and Mr. Milling may be kind of going at this. It just seems a little odd that with as involved as the neighborhood is, I mean, it's obviously, a very active and
Right.
they communicate. In 2016, there was nothing.
We had
and
no-
now
or
in two-
I had
and now
no
in 2000,
awareness
and I'm
then.
not talking about you, I'm talking about the neighborhood, but now in 2018, we have this. I find that a little odd. I'm not making any accusations one way or the other, but it just seems odd to me that there was none.
There was, on my part, there was no awareness that this was the proposal in 2016.
Okay, thank you.
Hold on, before you depart, I want to clarify for my own understanding. In 2016, do you know that there was a proposal for a bank and a pharmacy?
In 2016, I have a vague memory of knowing that a bank could be built there.
Okay, so you knew that there was some development.
Something. And
But
like,
not necessarily a
my
car wash.
point of view, I'm not
Okay.
opposed to neighborhood-friendly development.
Okay, I just asked for
I'm
clarification.
opposed to a car wash.
All right, thank you. All right, any other questions?
Mr.
Yes.
Chairman, just to clarify, the notice from the 2016 PUD was to allow shared access between two lots. The notice does not reference a use.
There we go.
Okay, but
We had no idea it was a car wash.
the
or I
previous
didn't.
notice for the PUD was for
Both of the notice,
in 2008 or whenever.
only in the rezonings was the use referenced, and that was in 2008.
Okay. And that was specific to the bank and the pharmacy?
At that time, yes,
Right,
sir.
and shared use for the PUD?
Correct. There was a much larger development proposed in 2008. The bank and the drugstore and the two lots at the corner, and a multifamily development down at this portion.
So there was other uses proposed at that time?
At that time, yes, sir.
Okay. Thank you. All right, I think we have time for one more, please. Good afternoon. Your name and
afternoon.
address?
I'm Rose McPhillips, and my address is 2867 Dolphin, which is just to the immediate east of the Purple on Dolphin Street. Yeah, that's where it is. And I own several different lots right in that same area. I have lived there, I'm embarrassed to say 1 years. So I'm real familiar with it, and in full disclosure, I'm also related to the Graffs. So, and it was part of the Graff property, which is my family home. I have come every time anything had to do with the development of the piece of property. My cousins know it. Some of them are here today. And so I have been here every single time. I was here when it got rezoned to the LB1 because I was concerned what was going to be next to me because I'm immediately to the east of it. And at that time, it was indicated that it was going to be a bank and a drugstore. That fell through, as did the R3 development that Gavin Bender was going to do in the back of the piece of property. So it's 4 pieces of property. There was a different type of shared access, I guess. There was a different road. You could only exit onto Dolphin Street going east. You couldn't turn in from there. So all of that stuff was there. I've come every single time. In answer to your question, Mr. Milling, I don't recall getting maybe I did, but I don't recall getting anything in 2016 because even if it was shared access, I would have looked it up. And so I don't recall getting any notice, and I certainly am within the area that needs to be notified. Maybe I just didn't get it. I don't know. But I don't recall it, and I don't recall seeing the sign out there. I'm not saying it wasn't, but I don't recall seeing the sign out there.
Just hold for a second and extend her time, please. If you will, silence, because I'm really focusing. I'm sorry. Go ahead.
I think the important thing is that I feel that Mr. Pipes and Mr. Myers are trying to circumvent what they need to do. And what they need to do, if they want to zone it B2, a full B2, they need to go and ask for a B2 zoning. That's certainly available to them to be able to do that. That's not what they're doing. What they're trying to do is circumvent it and take an easy way out. This is not proper for a use variance. As Mr. Stewart indicated, economic loss is not a problem. I'm not sure how much an economic loss it actually is. The bank obviously thought it was worth $675,000. Mr. Myers can turn around and sell it for $675,000. There are plenty of banks out there looking for space, or drugstores. You know, I don't think that it's proper for a use variance at this time. I think if the neighborhood had known in 2016 that there was a proposed car wash, because I too agree with my neighbors, first I heard of a car wash was in 2018. And I'm down the street from it. So, you know, I think this is the problem that we're having here is that I'm not sure that it's proper to be before this forum And I think it's more appropriate to either have appealed the city council's decision to court, or else make a proper application for a zoning request for a full B2. And I think at that time it would be fully opposed. Thank you.
Okay, before you depart, any questions? You said you were here in 2008 when it was initially
I was here in
requested.
2008, yes, I was.
And-
And I spoke then also.
What was proposed at that time?
Bank. It was Hancock Bank that was going in there.
Bank, a pharmacy?
It was going to be a drugstore. The one on the corner at Sage and Dolphin was to be the drugstore. The one next to it, which was the one that was sold to Mr. Myers eventually, was Hancock Bank. And what happened was is Hancock bought it, and then right around that time, they went into a merger with Whitney, so they didn't need the lot anymore because they moved into the Whitney building.
Okay, was the multifamily part of that?
Multifamily was part of it, and the LB1, which is the purple, was also part of it. All of it was done at the same time. Before that, that had been considered to be farmland or dairy land, because that's what it used to be. And they rezoned it for those uses for development. The neighborhood, as a general rule, didn't have an objection to some business use of the property, but at the time it was going to be, LB1. And so we wanted to make sure that there wasn't going to be a noise factor and things like this. That was addressed at that time. And even the, and actually, Mr. Anderson was the attorney for it, but there's a fence line along the east side, and it's covered with trees and bushes and stuff like this. There was even an argument at that time as to whether or not they were going to have to put up a fence or if they could use that as the buffer zone. So, yeah, I was here then.
Okay, all right. Once again, any questions of the board? All right, thank you.
Thank you.
Oh, Mr. Burris has a question for you.
My question is for Bert. Bert, I hate to put the pressure on you, but I come in late last night. I had about 5 emails, but I didn't read them. What I'd like for you to do, if you could, is give us a quick synopsis of items 6 and 7 as to what took, as quick as you can, not to put you on the spot.
I think you can have a seat now. Okay, thank you.
It'll be out. I didn't get a chance to read this stuff before that.
Well, item 6 is an appeal by the attorney representing Mr. Myers regarding a staff determination prepared by Ms. Pappas regarding the use of the property. And the chairman, based on legal advice, determined that that was not going to be heard by the board, that was not in the board's purview of review. And then item 7 is a request by the applicant for variance, assuming that when the property was rezoned in 2008 and was restricted apparently to a bank on this particular site and a drugstore next to it, they're asking for a variance from that rezoning to allow a car wash on the property. So you're right now only considering item number 7.
Okay, any questions?
Yeah, Mr. Chairman.
Mr. Metcalf?
For staff and or council, and I don't want to get too far in the weeds, but going back to 2008, the zoning change was tied in with a PUD, correct or not?
Condition number 2 on the zoning amendment required an approved PUD.
At what time? At any time?
In order to be compliant with the rezoning.
Okay, so a PUD was approved in 2016.
Correct.
Which, had it been acted on, would have been consistent with the original zoning in 2008. Everything would have been fine, basically.
Based on the information at that time.
Okay. PUD expired, was not acted on. It was approved, but not acted on, so it's gone.
They expire in 1 year unless extended.
Okay, so really the zoning was conditional. I question whether it was conditioned on a bank or a pharmacy. I don't think that really is the case, but anyway, so that until a PUD is approved, the property is not zoned B2.
It cannot be developed.
It can't be developed. So it may be on the record as being B2, but it was a conditional zoning change, not for use necessarily, but tied to an approved PUD.
It is tied to an approved PUD.
So it can be argued that it is not zoned B2 because the conditions of the 2008 zoning was not completed.
No permits or licenses for that address would be issued through planning and zoning until an approved PUD is in place.
Okay, thank you.
Any further questions, comments? Okay, would you like to speak in response?
Just very briefly. You heard Mr. Stewart mention that financial or economic loss is not a grounds for a variance, and while that is normally the case, that's not the end of the story. Variances can be issued in the case of financial or economic hardship where the burden is not common to the public at large, where he would suffer differently than others. And here, clearly, he does suffer differently. He was enabled, allowed, and not encouraged, but certainly facilitated his closing on this purchase by getting all land use and zoning approvals he needed, getting his PUD approved for a car wash. And I believe the reason the earlier questions were about notice, the PUD was just to share access, between multiple lots. It wasn't to permit a car wash, because a car wash was allowed by right under the B2 zone. So I don't think that was part of the notice that would have gone out. But again, I wasn't involved in the 16 application. The reality is that none of the laws have changed since he bought the property. It was previously approved as a PUD. Nothing has changed in the city at all with regard to that property or the zoning code as a larger level of it or anything else. And I think it's manifestly unjust and unfair to Mr. Myers to have the city revisit its decision on what's a permitted use on that site after they've already told him that a car wash was allowed. That's our unnecessary hardship.
Okay, once again, any questions?
Yeah, Mr. Chairman.
Yes, Mr.
Casey,
Yep.
I'm going to put you on the spot. You probably have the best legal mind in the city when it comes to these matters. Do you I think you do.
No comment.
Do you concur with discussion that I just had with the staff that the 2008 zoning is conditioned on an approved PUD and acted on? Acted on meaning the PUD be approved, the permits and licenses being issued. If you don't want to answer that,
no, I'm going to answer it. I believe that the 2008 ordinance is clear, and it looks like all the other ordinances the city has. It rezoned it, if you just focus on the B2 one, not the LB and the...
Okay.
It rezoned it to B2, and then it said, all uses, allowed, all structures allowed, and then it said, but it can't be used that way until all the conditions set forth below have been complied with. Completion of the subdivision process, that was done. Regarding the final plat prior to the, limited to an approved PUD as may be required to be amended. That was condition number 2. Now to your, and then there were comply with tree and, I don't mean to skip over it, but not relevant to this. I agree that this is supposed to be developed as a PUD. It could be developed as any PUD, though. It's not limited to what the PUD request was at the time. I have had them before. The Walmart out by Providence, it was rezoned and it was limited to a specific PUD. And when we tried to change the size of the building, I had a meeting, we had to advertise for rezoning from B2 to B2 because we were changing the PUD, and it was deemed a rezoning because we had to instead say, and instead of this approved PUD, it had to be an approved PUD. And this was the language that was there, where you have to have an approved PUD. It could be any PUD.
Right, but I think this brings a circle back. There's not an approved PUD.
And we went to get an approved PUD.
Okay, hold on. There's not one today.
Correct.
Okay, and the reason there's not one is because of the Planning Commission and the City Council.
The Planning Commission denied it, the City Council
Okay, so
affirmed it.
the circle's coming back around, City Council and Planning Commission. Is that not where you should be?
They denied it, but they said a car wash wouldn't be allowed there, period.
Right, but for whatever reason.
But
they denied your PUD, which doesn't allow anything in B2, because you have to have an approved PUD before the property can be officially B2 or developed as B2. So I think what our council is saying that you very well may be entitled to some relief. I mean, that's a bad situation that you're in, and I feel for you. But I think what we may be hearing, not speaking for the rest of the board, is that as this comes, we get more clarity with it, it seems to be more clear that your relief needs to be elsewhere.
Well, and we're giving an opportunity to get relief here, and we felt this was an appropriate request for this board to grant a variance to avoid an unnecessary hardship, and to try to avoid where we were going. But the Planning Commission denied the PUD for the expressed reason that a car wash wasn't allowed there, and we think that was, we don't think that's correct. We think this board has the ability to solve that problem, and then we'd go back and get a PUD. I mean, we're not saying we don't have to get a PUD, but we need to get some clarity on what we can build there as a permitted use. And we tried to get that queued up through a request from the city of what can we build there. And in the alternative, if we don't like that answer, can we get a variance from it to give this board an opportunity to create a path forward?
Okay, thank you, Casey.
Thank you.
Okay, any other questions?
Thank you, Mr. Chairman.
Thank you. Mr. Montes, any other comments in reference to this? I would say that the applicant could request a use variance, whether it was an R1 or a B2. I mean, we still have that as a...
I believe you're correct.
Correct.
On that.
So if the PUD has went away and therefore the zoning variance is discontinued, it would still be his right to request a use variance.
I would agree with that.
Okay. Correct. Okay. Any other questions?
And I would
or
add to
comments?
that, the standard would be the same, whether it's a R1 or
the hardship.
Yes.
Correct. As Mr. Burrows stated, and I'm sure many of us have discovered, there is a lot of documents that came with this particular two applications. And between that and all the comments and statements that were sent in either online or via submission. Any other comments, questions of the board? I would ask the board, have you had ample time to review all the documents associated with this particular application? Okay. How about you, gentlemen?
Mr. Chairman, I'll say, with regards to that, I mean, this is probably one of the more complicated applications since I've been on the board. And, unfortunately, we didn't receive the package until late Friday. And, trying to interpret the history of what went on and then interpret, legal opinion, which I'd say the majority of us don't have, that experience or probably the knowledge to know, which direction that's supposed to go. I don't know. I mean, it seems like an extremely unfortunate situation. I mean, being in the commercial real estate business, I mean, it appears to me that, Mr. Myers went through what we typically deem as reasonable steps of due diligence to, satisfy himself that he was allowed to develop that property for his intended use. And, how, that got through that process and he closed on the property. I mean, that seems like a hardship to me, but is that the standard of hardship that we're supposed to look at, as this board? It also seems to me that this is, maybe not the appropriate venue to, give relief in order to avoid, what is a more appropriate path to figure out, what's the right step. So I don't know that I have, a final comment or solution, but it's a very tough situation, in my opinion.
Okay, any other comments?
Mr. Chairman?
Yes.
I guess question for you. It did kind of come in late because there was a lot to have to do, both from the staff, and then we have a situation where our council has been temporarily replaced, but only as of Thursday or Friday, and I'm not sure how long Mr. Minus has had to research this as well, being brought in late. I just asked you, do you feel like that the board has had enough, that our board's council has had enough time to adequately review and to give the board render a legal opinion? We've got from the gentleman up there, we got a page document that it was very, very well researched, I'll have to say, as well as Minister Pipes. So I'm just wondering, do you feel like that we've gotten enough at this point, or you?
Well, that's why I posed the question, is whether or not this board wishes to hold it over for 30 days for ample time to review, or do you feel like you've had ample, you're educated and familiar with the documents enough that we can make a decision, render a decision today? If one of you wish to make a motion to hold over, I'll consider it.
Mr. Chairman, I think that may be a good idea, but I want to make sure that something gets done during that. And so it might be that if the board does choose to hold over, that that during that time that we ask our council to give it a more in-depth review and give us his legal opinion, so that we can rely on that, because this is a complicated matter and there's a lot going on both sides. And so I would want, as a board member at large, to feel comfortable in relying on something other than just as Mr. Milling said, we have some knowledge, but we're not legal scholars. So I would feel more comfortable if the board had an official, let's say, opinion rendered by our council.
Second to the motion. I'll take that as being one.
Well, I didn't make a motion. I'm just at this point talking.
Take it as being one.
I wanted to get Mr. Chairman, could I get your input on that?
I voiced or posed a question based on my concern that we have not had ample time.
That being the case, I make that motion.
Second again.
I have a second. Any further discussion to hold this over 30 days to rent our attorney or legal representative provide us guidance whether or not, and Mr. Metcalf, if you'll clarify what kind of.
I just would like something for the board to have in writing, a legal opinion from our counsel as to his opinion, one as to maybe as to our authority on the first issue, on the first application of.
No, I've already made a motion to deny that.
Okay, well that's over with
authority of the board.
Then just the facts of this case here.
Just the variance.
Yeah, just the variance.
Okay.
Is that okay with you?
Yes.
Okay, I have a motion with a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Okay, motion carries.
Thank you.
Now, obviously, many of you came here today to hear a decision. I think it's the benefit of both the applicant and you that we have an opportunity to totally review this. and you have a legal representative that has come before us as well, that you give us time to review it and to have some form interpretation and advice from our counsel. If you have questions, I'll have to defer you to the staff, because we have to move on with our agenda, and I think in fairness to everyone, we need to make sure we have all the details.
Mr. Chairman, I
Yes.
will say, just so everyone knows, the board's next meeting will be Monday, January 7th.
Okay.
So that will be the meeting day. And can we have a 5-minute recess?
Yeah. Okay. All right. The motion carries, correct? Unanimous, all right? We'll 5-minute recess to allow those of you that have joined us today to depart if you want, and then we'll reconvene in 5 minutes. Thank you.
Yes, sounds good.
Yeah, I think there got a few people.
It's hot.
You're going to have rider's cramp on that one.
I'm here. Just
You
got
timed it. We give you plenty of time.
Thank you, Judge. He's not now. That's the same thing. Just submit your opinion in writing and get it held here. Let's win the game first. Let's win the semifinal game first.
We're going to win that game. Where is it? Where is it? Oh, is it?
I got invited to go. Somebody else there. I had to turn down.
Local, Mobile County, Mobile County. Steel. That was a burglar. Just steel. Hey there, how are you?
I give you a chance, we can get property
Nah, they're gonna be in order now. I'm sorry. Sorry, 13, you speaking against it or in favor? I saw a bunch of people were for and a bunch of people were against.
It's not going,
Shouldn't be, they should. Yeah. Free. It was Fulton, it was Court or Fulton and Dolphin, wasn't it? Wasn't that the first one? Wasn't that the lawyer's office is? Wasn't that the first? Or was the CPA office across the street the first? Oh, yeah, yeah, yeah.
And that's where last year was.
That's right, yeah, yeah. That's what I was thinking of. Yeah.
You know, but that before zoning.
Yeah.
The never had hit.
Yeah.
But Foster Street, that block between Fulton and Upper Street.
Mhm.
It's residential
Yeah.
until
Yeah.
it's nothing commercial.
Yeah.
That block.
Yeah. Well, yeah, I think this one will get denied. But I'm sorry, yeah, they're gonna take him in order now. Sorry.
They said don't be sure. All right.
I've got plenty of room, Doug, if I can't make it through that. I've got pretty good.
It's just habit. People do it to me. It's just habit.
And it's not about...
Hey, well, I shouldn't have come back. Now I know I'm not the smartest guy in Mobile. On the
Hi. Good afternoon. My name is Sarah Kent. I live at 1119 Street. I'm the owner of Sunshine Sue's Play Garden, and we are a boutique children's activity center that involves birthday parties, music and art classes, and also we at the moment have a Mother's Day out type drop-off situation that's 4 hours or under. We are also involved in different activities with the community. We have a partnership with the Down Syndrome Society of Mobile, and also currently with the VIA Center. We have a pop-up location there at the moment. We've been doing intergenerational activities with the Grand Friends program there with our activities that are already ready. We are a unique business in Mobile. We're not unique nationally or internationally. There are lots of other businesses around the country and world that are like ours. But we're unique in Mobile in that we focus on non-electronic play, very small numbers, high quality, elevated customer service. And we have been searching for a location and found 2200. And we have been interested in this because we very much want to be a part of a neighborhood, because our business is very well suited to be in a neighborhood because the young families are who we serve. Our age range that we serve is 0 to 6. And we have a lot of clients that do reside in that area. We had a lot of people that wanted to come to the meeting today to support us, but it's school pickup time, and it was a very hard time for parents to be able to be here. But we focus on very small numbers and quality over quantity. And so our ask for a zoning variance for this property is because that there is nowhere in the area for children to safely play. There are playgrounds in the immediate area. The neighborhood is ultimately walkable, but there aren't a whole lot of amenities for families to walk to in the neighborhood. And so what we are looking to do is provide services where not only somebody can come and play with their child or grandchild, but they can also drop off their child just for one day without being enrolled in a permanent program, which is unique to us at the moment in Mobile. We've been providing these services since 2003, and we found that especially with stay-at-home mothers and fathers, that they had a need for being able to drop off their child just for one day, for 2 days, as many days as they needed, without being involved in a continuing program. So we offer a lot of services that others do not because we focus on younger children 0 to 6. There are very few art programs for children 0 to 6 in Mobile. There are very few music programs for children in Midtown 0 to 6. We have just finished our certification for kinder music training, if you're familiar with that, and we'll be offering classes for that. We believe that a lot of the comments that we've received from the public, and I'm sure that you've received as well, are part of it is a lack of familiarity with our business model, because I think a lot of people think that we're a high traffic business, that we would be serving a large number of children at the same time. And there had even been comments because of our site plan, the indoor site plan, why we had seating for 60 people inside. And that is because our parties take 3 hours apiece to decorate for. And so with that being said, instead of having to stop what we're doing in between parties and decorate for 3 hours, we could decorate for two days and go on from there. We think we're uniquely suited to be in a neighborhood. Much of that is because we will be serving the neighborhood and also surrounding areas of Ashland Place, Oakley, and those other areas. We feel like this board, I know there's been a lot of discussions about precedents, but we feel like this board has the unique opportunity to curate a neighborhood business portfolio and what they're able to allow in a business and what fits and what doesn't. And we believe that we do fit with a neighborhood, and that we would have a very positive aspect on a neighborhood, and that families would even consider buying a property in this neighborhood due to the fact that we were there and had amenities to walk to. The staff report pointed out something very interesting to us. The map from Mobile states that that specific area is classified as a mixed density. And I quote with the staff report, like low-density areas, mixed-density residential areas may incorporate compatibly scaled and sited complementary uses, such as neighborhood retail, office uses, schools, playgrounds and parks, churches, and other amenities that create a complete neighborhood fabric and provide safe and convenient access to daily necessities.
Okay. If you'll summarize, if you have.
Thank you. I appreciate that. We feel as though we would be an unobtrusive neighbor in the neighborhood, and actually we do, if granted the variance and everything goes where we are able to move into the area, that we would even offer up our facilities for community events that are non-political, and that we feel like we would be an asset to the neighborhood. We feel like best and highest use of a property because of the size, the land, and the fact that this property is much larger than in the others in the immediate area. The best and highest use would actually be for us to be able, for all community members to be able to use this property rather than just one family.
Okay. Any questions of the board for the applicant? Okay, I have two for you.
Yes, sir.
The way you describe it, you currently have a facility somewhere else?
Well, we had a facility, and then our lease ran out, and we are currently at the VIA Center in a pop-up location on a much smaller scale.
Okay, what size of facility did you have before?
We had about a 1,800 square foot facility, and we were only had one party room, and so we were only able to do 2 parties a day because of the time it took in between parties to decorate, because we do provide highly elaborately decorated parties. And so with our new model, we would be able to do more parties per day, possibly up to 4, because of the fact that we would have an extra party room. Also, we really, with our Kindermusik certification that just got passed, we need an extra room to be able to teach those classes. We're not constantly moving tables and chairs in and out of rooms.
Okay, on the occupancy for the party room, what was your proposed occupancy?
The proposed occupancy had 24 chairs in a party room, so each party room would have 24 chairs.
So upwards of, how many party rooms again, 4?
2.
2. So 48 potentially at a time.
But no, sir, we wouldn't have, one would be occupied at a time, then they would leave, and then another, because obviously we knew we wouldn't be able to fit that much parking in a zone, or an area of that size anyway, so we would have to wait and make sure everyone left before we would be able to accept another party to come in.
Now, you stated that there were several individuals, property owners that were in support of this, that for whatever reason were unable to attend. We received several documents and written online comments in opposition. Did you try to meet with any of those individuals or as a group?
Yes, sir. We had a public meeting and advertised it on Nextdoor and also on our Facebook page. We had a public meeting on November 28th at 6:30 p.m. at the VIA Center.
And what was the outcome of that meeting?
We had 2 people show up, and we answered their questions and made a presentation of our plans and tried to do our best to explain our business model to them so that they had a better idea of who we were.
Okay.
These are some photographs of some of our activities.
Okay. Once again, any questions of the board for the applicant?
I do, Mr. Chairman.
Mr. Lee.
Sarah, hey, obviously, I guess from a lot of positive comments, I think, on the website as far as your business model, the need in the community. I guess the question, or I guess maybe first addressing a comment you said that we have a unique position, I guess, to be able to incorporate, business-friendly, businesses into the neighborhood. Although I don't think that's quite accurate, because I think as a board, we're charged with, what is the hardship for that property, that it can't be used as it's currently zoned and then would require a variance. Can you speak to that at all?
Well, I will say that the house is by far the most expensive house in the immediate area and was on the market for, I believe, about 10 months prior to our group making an offer. I believe that the house it's just an amazing piece of history, and it's in great shape. The layout of it is not very conducive for modern living, and I think that's part of the reason why it was on the market so long. The center hallway is 38 by 8, which I think with a lot of younger families, homeowners, home buyers, they would think that that would be not usable space in a home to buy. For example, the master bedroom is a shared bathroom with another bedroom. The master closet is in the hallway. So I imagine the cost for a homeowner to mow almost an acre's worth of grass would be a deterrent for a lot of potential homeowners as well. But I believe that when we look through the property as the business, we just felt as though the layout and our customers are so used to the high customer service that we provide that keeping up a building would be obviously in our best interest because of the fact that our customers demand the best from us, and they obviously wouldn't want to bring their children to a dilapidated building. And so felt as though the current layout, which we are only changing with, if required by the city, to do an ADA bathroom and add a ramp, would be the only layout change in the entire house that we would provide. We would paint. That would be the only thing that we would do. Would be uniquely suited for us, and we feel as though the reason the house didn't have any offers prior to our offer is because it's just the layout isn't really conducive to modern living, and the kitchen is also not very renovated, and so the amount of money that somebody would have to put into that to bring it up to that standard of modern living would way outprice the neighborhood, and so I think that's why it was a deterrent for a lot of families, and that's why I think we're uniquely suited to come in there, because we don't have to change a thing.
Okay, any other questions of the board? Okay, thank you.
Thank
Is there anyone that's present wishes to speak in favor today of this application? Yes, please. Good afternoon. Your name and address?
My name is Lee Burnham. I live at 57 Bienville Avenue. My husband and I just started looking for a new house maybe a year or two ago, and he always said if that house came on the market that we would look at it. It is one of the most beautiful homes in Midtown. When he saw the for sale sign, we started looking at it online, discussing it, and through talking with friends that are realtors, they kind of gave us the layout of the inside. It's 3-bedroom, 3-bath. There is no master bathroom suite. It is a shared bathroom, which meaning we would be sharing a bedroom with one of our boys. The closet space, like Sarah said, is in the hallway, so there's no closets in the bedroom. The kitchen, I was told by my friend who has seen my kitchen, it's comparable to what I have now, which is what I was not looking for. The price point, I think for the price they were asking for the home, and I know that when the house was built, that's how they built houses then, and there's some things you could change and there's some things you can't. But for the asking prices of the house and what we were looking for, we just didn't feel it was suitable for our needs, so we're still looking for a home. Like I said, I love the area. I've been here 20 years. And for Sunshine Sue, knowing Sarah and what she offers with her little business, I really believe that would be an asset in that location. The neighborhood, what she offers for children, she teaches through music, art, interactive play, socialization. It's, and I know there are many families with young children that would love to have that within walking distance. I've recommended friends to her that they love it. I myself, a mother of 2, when my boys were little, I don't want to call it a mom's day out because it's a children's play center, but for me, having that flexibility of a place to drop my kids off 1 day a week or 4 days a week or last minute, an emergency, a doctor's appointment. Having that available was a blessing. I really, would love to see it at that location. Yeah, I think that's all I have to say.
All right, thank you.
Thank you.
Any questions? Okay, anyone else? Yes, have a good day. Thank you. Your name and address, please.
Julia Sledge. I live at 1903 Old Shell Road. It's around the corner from the proposed new location. I just want to speak to how wonderful the women who own and run this adorable business, how amazing they are. I fell in love with Sunshine Sue's about 5 years ago. I've got a 10-month-old, a 5-year-old, and almost 6 years old. But on a very hot Mobile day, we didn't have anything to do. We dropped into Sunshine Sue's and stayed for open play for a couple of hours. Since then, I have been to their old location probably 100 times, maybe more. We've had birthday parties there. Even after my kid at school full-time, we would go to art class after school. My 10-month-old goes sometimes with a nanny when I can't take her for open play. We're very excited about the music opportunity. I really need them to open back up so Liesl can get in there, my 10-month-old. It's a wonderful thing for mothers to have in town, not to have to sign your child up for a full-time kindergarten. If you want to stay flexible and have your baby with you, but like the other mother said, to be able to drop your child off for a couple of hours, and I mean really it's 9 to 1, but those 4 hours in a mother's world is essential. It's amazing to be able to trust the women. And I know that this house is in the middle of a neighborhood. It's in the middle of my neighborhood. It's in the middle of a lot of my friends' neighborhoods. But how wonderful it would be to be able to walk my children and have this down the street. And I know that Sarah and her family would take wonderful care of this property. She's renovated and taken care of a beautiful home downtown on Dauphin Street. And I mean, from scratch, really. I think they did it all by themselves. So I just would really ask that you guys give this variance to them and do all the moms of Mobile a big favor. Thank you.
Thank you.
Mm-hmm.
All right. Anyone else? I think we've got room for one more. If you have anything to add, okay. All right. Opposition. Pick your best four, as I always say. Good afternoon.
Yes, but anyway. I'm Robbie Lynn Irvine. I live at 57 Williams Court. And Williams Court does not go through to Dauphin Street, but it is only like 4 houses away from Dauphin Street. Since this has come up, I have heard absolutely fabulous things about this operation, that it's handled beautifully and everything. However, I am opposed to it going in where it's going in. I have lived within 5 blocks of this house for probably since I was 13, which is a number of years ago. I have lived in my current house for 51 years. I have watched what happens when a commercial property goes into a block of residential houses. Right now, from Upham Street to Hurlbut, there's nothing but residential houses. There's a Wawa on the corner of Dauphin and Hurlbut. From Fulton Street all the way to Sims Avenue, there's nothing but residential houses. Between Fulton Street and Upham Street, 1 block, it used to be all residential houses. Now it is nothing but commercial. And commercial is back on the corner of has always been, as long as I've been around, has been commercial on Upham and Old Shell Road. But Dauphin Street itself has been residential and pretty much stayed that way. There are a few little pockets otherwise for years on the corner of Fulton and Dolphin Street. Bumper Lines had, his insurance company went there when there was no zoning, and it is now a law office. But for the most part, it is residential. When you start giving commercial pieces, properties, commercial operations, the opportunity to go in slap dab in the middle of a residential block, then you're opening it up for any time somebody has a slight problem on selling their house to sell it for a commercial piece of real estate. I've also sold real estate for 40 years. And I can tell you something, having lived in Midtown for as long as I've lived in Mobile, people move to Midtown, Oakley, Garden District, Atonte Square because of those wide halls, and they get over the fact that the master bedroom does not have a master bath. They will make adjustments because being in those type of houses, and this house, which I still call the Greer House, is a unique piece of property for that block and for the whole of Dolphin Street, and to put a commercial piece of business in there is a major, major mistake. That's it.
Any questions? All right, thank you.
Thank you.
Next, please. Good afternoon. Name and address.
I'm Christy Guston. My address is 2003 Dolphin Street. I'm on the corner of South and Dolphin, the old Dumas house, if y'all lived here for a long time. What I wanted just to talk about also in real estate, and of course I live down the street, it's a great business, of course, but no matter how great a business is, we need to protect our residential blocks that we have left on Dolphin Street. I want y'all to just get in your mind, picture the area of Dolphin Street that is to the east of South Ann Street. East of South Ann Street all the way to Broad Street. I don't know if y'all, I'm sure y'all have looked at the zoning since y'all are the Board of Zoning Adjustments. If you look at that, all the zoning is there's no more residential there, like none. And so, of course, there's beautiful houses there, but they're mostly taken up by law firms. Some people do live there, but it's, you know, as you can imagine, that's not the best thing for a neighborhood. And if you look, like anyone can look at this, you could look on Zillow, and I can't believe I'm telling y'all to look on Zillow because as a real estate agent, I hate Zillow. But right now, you can see like valuations on there. And they're not always completely accurate, but you can see on there that that section is like much lower valuations than if you go west of South Ann Street. If you look at comparables, you'll also see that on average they're about 80,000, 100,000 lower, like to the east of South Ann. And so what I'm asking y'all as a homeowner that lives at 2003 Dolphin Street, which could easily become a law firm, and I promise all my neighbors that I will never do that to y'all, ever. Ever. And I would never, you know, I would just never do that. But I'm asking y'all just to stick with how the zoning is, the zoning residential. Please, in the future, because this always comes up, I know in the past there have been at least 3 that I've seen, for instance, across the street from me, 2012, someone came before the board and asked for, you know, a variance and a hardship, you know, request because they had bought a business and they thought they could do a business there, and you know, wah, you know, and fortunately y'all ended up making the right decision saying no, sorry, it needs to be a residence and be zoned as residence. So I just would like y'all just for anywhere, not just Dolphin Street, other places such as Broad Street, around the city, because it does all affect us. It affects residential owners who put money into their homes. I'm one of many who put a lot of money into my home, and I'm still putting money into my home. But I just ask y'all to do that, and I know that y'all will make the right decision because I've seen y'all do it 3 times in the past, and thank you from the bottom of my heart.
Okay, any questions of the board? All right, thank you.
Thanks.
Time for 2 more? Anything new to add? Good afternoon. Name and address, please.
Good afternoon. I'm Janelle Finley Adams, and I live at 2202 Dolphin Street. And that is the property right next door to the proposed Sunshine Sue's Play Place. And we have only owned the home. We moved in Thanksgiving week, but that house did belong to grandmother, so I know this home very, very well and have been living in that house in and out since my whole life. And while what Sunshine Shoe offers is great for the community, and as someone who does not have children could potentially be great, but I just particularly do not want to live next door to a business. With my husband, chose to stay in Midtown, chose to stay in the city of Mobile. We could have gone to West Mobile, we could have gone to Saraland, we could have gone all over, but it's something special about Midtown. I grew up living in downtown Mobile. I went to Murphy High School, and Midtown Mobile is where I want to be and where I want to raise my children, but I also want to raise my children with neighbors next door on Saturday mornings and not birthday parties. The traffic already just in the couple of weeks that we have been living there can be a nightmare now that Florida Street is back going and back open. And just to imagine a Saturday or a Friday afternoon and me coming home and wanting to have friends over to my house, but with the amount of traffic coming in and out for a birthday party or a parents' night out or a drop-off, it just does not seem conducive. While that home is beautiful, and like she said, young people who move in don't want wide hallways. Well, I just moved into a home with wide hallways. I will eventually share a bathroom with my kids. My own closets are not in my master bedroom, and it does take a special person who does want that. And while the homeowner might not want to wait that long to find that person, there are more and more young people. I have more and more friends moving back into the city of Mobile, looking to live in Midtown, looking to live in homes that way, and we want that neighborhood feel. I've walked to Publix plenty of times, and I enjoy that, and I just don't think it would be best in the future of our neighborhood to have a business and to open that up to businesses, because she could be there 2 months, she could be there 2 years, and then who says that next thing you know we don't have a law office or even a Dairy Queen, who knows? And I just think to keep the character and the charm of what Midtown and downtown residents look for, you have to keep that street residential, and you have to please consider not putting a business anywhere on Dauphin in that area, because it just takes away from what those of us who do buy a house and do put the investment into the upkeep and to making it more modern for ourselves. You have to kind of take that in consideration. So thank you. Thank you.
All right. Any questions? Just a response, or a comment is that if we were to consider it, it would be specific to this use, that Dairy Queen or somebody else can't come in after a later date.
Okay, I'm
just
still
as a
opposed,
clarification.
but thank you.
Thank you.
Thank you.
All right, anyone else? Good afternoon.
I was not really prepared to speak, but I'm Diana Allen. I live at 2166 Dolphin Street, which is on the other side, right next door. I've been in my house for 27 years. I don't have a master bathroom attached to my bedroom. You know, the house next door, which is the Greer property, that's what we refer to it as, I believe it was built probably around the turn of the century. It has been residential during the entire time. And maybe someone hasn't bought it in the last 8 months, but that does not mean that someone will not buy it. A family can move in. Since I've lived at my residence, we've had 3 different owners of that property. No one has tried to make it commercial. There are daycare centers around the corner. Ashland Place has a daycare center. Dauphin Way Methodist, there are many daycare centers around in the area. Another point, there are many commercial properties in the area that are empty, that are for sale, that are for rent, that you don't have to get a variance or a rezoning in order to put in a daycare center. I turned in some petitions with over 50 names of people in the neighborhood that are against this variance going in.
Whoops, sorry. Okay, any questions to the board? She mentioned that there was an opportunity for the neighborhood to meet, that they, I think it was the 28th, you said, or 29th?
Yes.
Okay. Did y'all know about
I
the
was
meeting?
there, yes.
Okay, so
I was
you were
there.
one in attendance.
I was one of the ones.
Did,
And I'm sure that, and she told us what, about her program, what they do, what a nice program it is, and I'm sure it is somewhere else. I just don't think that we should, this house is in the middle of a residential block. So, and as I said, I think that there are many other places, locations that are already zoned. Why would you take a house where someone's lived in it for over 100 years and change the variance?
okay. All right, well, once again, thank you.
Thank you.
Do you have any response to the statements? Kind of keep it brief.
Sure. I just have some brief comments. I myself live in a home that was a residence for 100 years. It was renovated into a business for 20 years. And then, excuse me, my family renovated it back into a home. Part of the reason a variance seemed like the right opportunity for us here is that that opportunity would be available for a family again if we were to ever vacate the properties. It would remain zoned R1. We feel as though Dauphin Street and Midtown in general, excuse me, I'm so sorry. Ms. Finley mentioned that people move to Midtown and live in the city. Well, part of living in a neighborhood is having amenities in a neighborhood and being able to possibly walk to an amenity. And one of the things that we feel as though we would fulfill a niche is having families be able to take advantage of our amenity within a walking distance. We feel as though we would be a very low-impact neighbor as far as traffic on Dauphin Street. We already know that Dauphin Street is a very busy street as it is. I don't think that us having 15 kids that usually are part of a sibling group, maybe 10 cars come in for a birthday party, is going to make a huge impact of traffic on Dauphin Street at any one time. But we do feel like uniquely situated to be in a home instead of a business building, because lots of people don't come to a strip mall to bring their child to drop them off. They want them to have a piece of a yard to play in. They want them to be in a warm and welcoming environment, and that's the type of business model we have tried to set up, and I believe that our families expect from us now.
Well, it sounds like everyone's positive about your business model, just not necessarily the location.
We understand.
And this board specifically has to consider hardship.
Right.
And you're describing the layout of the property, the size of the lot as the hardship. Is that my understanding?
It is, and also the fact that the market of places to safely play with or without your child in that neighborhood are greatly underserved.
Okay. All right. Any questions of the board for the applicant?
One more, Mr. Chairman.
Yes.
Obviously, I guess you've looked at a lot of different places
We have.
since your previous location, and I agree with you. I mean, we're at an interesting time, I think, because you have a lot of resurgence back into Midtown and downtown, and trying to figure out how to mix the residential and the commercial, and how to make things more walkable. What I guess two questions. One, have you just not found anything that's more commercially related or already zoned? And then secondly, what specifically attracted you to this? Is it because of its location around the neighborhoods? Was it, the layout and very limited to do?
We searched high and low. I think that the Gulf Coast MLS and LoopNet, they've probably banned me at this point because I'm on it every single day. We want to stay in Midtown, and I mean, obviously we could change it, but our logo says Midtown Mobile. I've lived in Midtown since 1993. I'm originally from Fairhope, and I have no interest in leaving Midtown. I call it home, and I want my business to be in Midtown because I wanted to serve Midtown families, because I felt as though there were so many things available to Spring Hill and West Mobile families. You know, the number of downtown families is growing, but still not a significant number. But Midtown has always had young families, and part of it is because some of the homes are smaller and more affordable, but there are some grand old homes there. So we looked and looked, and none of the commercial properties felt right to us because of our business model and the way that parents trust us to provide a very wholesome, and also since we focus on arts and music, we felt as though a commercial standard property wasn't right for us as well. Most of them didn't have the space that we needed if it was an older property. So we found, when we found several different properties that may have worked. We went to rent a couple different properties, and then people decided they wanted to sell, and at the time the price point was way out of our range. And when we found 2200 Dauphin Street, my manager Kelly and I went to look at it, and we walked in there and we were just like, this is exactly what we would have drawn up for ourselves had we been able to do so. It's in the heart of Midtown. It's right where families would be. It's walkable. It's right for our business model because we would be a neighborhood business. We would not be a business that would interrupt anybody's activities. Nobody would have any excessive noise. We'd already designated our entire campus at our previous location non-smoking. We are very conscientious and very health-oriented about how we would be a neighbor, and we would commit to be an exceptional neighbor in the neighborhood. That's exactly how we want to be seen as a neighbor and not necessarily a neighborhood business.
Okay, thank you.
Thank you.
Any further questions? All right, that will conclude our comment and statements. Discussion of the board, comments? All right, the application as presented, the staff had recommended for denial, and the applicant has stated with, I think, great detail how she intended to utilize the property. We have a significant number of individuals that have expressed opposition in writing and signed a petition. So the chair will entertain a motion.
Mr. Chairman.
Yes.
Move for the deny.
I have a motion to deny. Do I have a second?
Second.
Have a second. Any further comment? All those in favor of the motion say aye. Aye. Anyone opposed?
Yes.
Okay, I have 6 for the motion and 1 in opposition. Appreciate your time. If you'll get with staff if you have questions. All right. Those of you that were staying for this, if you want to depart, I'll give you a minute or so. Do so. Thank you again. Yes. Well, let me see if we got any others on this agenda that's, we've got a quorum, so. Okay, I have a question for the board. Is there any member of the board that has to recuse themselves for any of the other applications? Okay. Mr. Davis has a prior commitment that he needs to depart, so we'll remain with 6, and we'll have a quorum and enough to vote to affirm a motion one way or the other. So, all right, well, thank you.
Thank you, sir.
All right. Okay, we will go back to the very beginning of the agenda. Thank you all again for your patience. We are on, I believe it's a holdover, 6210 Rainbow Signs, 1485 Satchel Paige Drive. Is our applicant here? Or did they leave with everyone else? All right, we'll move on for the moment. Okay, application 6219, 6048, 3669, 59, Central Presbyterian Church. This is 1260, 1262 Dauphin Street. Your name and address, please.
Sharon Hageman, 3978 Wimbledon Park.
Okay, and this application was recommended for denial. You want to tell us why we ought to consider otherwise?
I would be happy to.
Pull your mic a little closer.
Okay. Is that better?
Yes.
Okay. All right. Central Presbyterian opened its older building to a group of artists. There's all sorts of people there, but there's a group of artists there, and we basically have just studios. Now, according to this, I did not, when I wrote this out, I wrote artist studios, not artist galleries. There is no designation in the state of Alabama for artist studios. An artist studio is simply an area, a room. Most of us have one room. I have 2, 3. But you have easels, lots of paint, and you're literally having people, your clients or your designers or whoever, come in and look at the art that you are designing, and then they will purchase it and take it out. There is a designation for photography studios, okay? Similar situation. An art gallery is a store. A lot of times it's open to the public. It has definite hours. We do not have that. An artist comes into her studio. You may work half a day. May only work 2 days a week. It's not open to the public in any way. Okay. The other thing is that our entrance is key coded. No one can come into Central Presbyterian to walk around and look into anybody's art studio without the artist being there, being asked in. So it's not a gallery. It's not comparable. Not comparable at all. Okay. One of the main reasons why we are interested in having this designation or being folded into this B1 zoning is because we cannot get business licenses without it. And that is one of my main concerns. I would like to have a business license. There on here it said special conditions with regard to other galleries in the area. Well, I know there's Ashton Gallery. There's a few galleries there, but that is nothing similar to what we do. It's just not comparable.
Okay, any questions for the applicant?
I've got one,
Yeah,
Mr. Chairman. As far as, I guess, read through the differentiation between a studio and a gallery, I mean, do you see any situation if the variance was granted that it could evolve into, a situation?
Key-coded, it's a community center.
Yeah.
It is strictly, if you come to Central Presbyterian, what you're going to find is a community center. It has it has a church there. We have a kitchen there where they have people that come in and cook. We have art studio. We have you cannot come in otherwise because of that. We're not in any way going to develop an art gallery. It's not feasible. There's many artists, but some of us have nothing more than basically a closet, and then some of us have bigger rooms. But the community there, all we were looking for is spaces out of our homes into an area where we could paint. As a matter of fact, most people do not want to be in our art studios because they do not want to get clothes contaminated with all the different things that we're throwing everywhere. So it's not a gallery in any way.
But Sharon, I guess, from that standpoint, I mean, my understanding of that property and the artists that work different uses there, I mean, if it did become a gallery, I'm not sure that would be completely inappropriate as well. I mean, if you look at the size of the property and the other things that are there, And I'm not saying that's what you're asking for, but I'm just saying, you know, my understanding of what you're asking for and my understanding of the property is you have a lot of artists who are operating kind of independently of each other in these, you know, different rooms. But the property itself is set up with all these different uses and, I mean, commercial, church, et cetera, kitchen.
But when you think of an art gallery, don't you think that you can just go in there and you walk in and you say, you know, I'm looking at some paintings, do you have anything this? And you know when you walk in that you are going to be able to take out your credit card and buy that. Well, that is not going to be available at our center because you've got to make an appointment with us. We don't have set hours. We have no storefront. We're not set up in any way. Like I said, you have to have a key, coded key in order to get in.
Thanks.
Okay, I have a question.
Yes, sir.
So currently, and maybe this will be something for more so for staff, but just hold for a second. As a Presbyterian church, they could have artists come in and utilize space anytime they want, just as part of their program currently, couldn't they?
That is correct, as long as it is a church-affiliated use. So if the church wanted to have artists come in, classes or wanted to have a you know, Christmas sale, artists come in and produce the work and sell.
Like they're doing. So, okay, back to my question for you. Excuse me.
I'm sorry.
You stated you would like to get a business license. What do you want to get a business license if you could
Because I want to buy my supplies using a discount.
You got that, did you?
I picked really large pieces, like 60 by 60, and I have big wood panels, and I need that discount.
I won't disagree. I just wonder whether or not that could be done through it.
Well, one thing that could occur is that while this may be the studio space for the artist to produce work, they could obtain home occupation licenses for where they actually live. That would allow them to get a business license as a private artist, and then they could actually potentially do the work at this facility.
Right. That's what I was thinking, that you didn't necessarily have to have the license at the Presbyterian Church. You could actually have the home-based and still use the space as you intend.
I guess I could, but
yeah,
I was hoping to do it through this way.
Yeah.
Understand.
Okay. Any other questions for the applicant? Mr. Metcalf?
No.
Okay. All right. Do you have something to add, sir?
Christopher Bullock, pastor at Central Presbyterian Church.
Your address?
I reside at 304 South Georgia Avenue. Sharon came to me about, I want to say almost 6 months ago, and told me she was trying to get a business license. She may say to you that it's for her supplies, but the technical reason she wanted a business license was to pay taxes to the city of Mobile. And so there are 3 artists in the building that, you know, and it is, by the way, our charter includes a provision that recognizes what they are doing as part of the church. We did that on the basis of council 2 years ago. Likewise, when we came here before our previous variance, the Montessori school, of which this one refers to, we did the exact same thing, just for whatever the legal reason was at that time. So, while I understand that they could have an in-home, I proceeded with Sharon and Ardith Goodwin and Shauna Myrie because they really wanted to get right with you guys. So I'm here to support that. If there's another theory and based out of home, that is fine as well. We're not trying to, literally, their paintings cost enough, and someone comes in and says, I'd like that painting, that they feel like it's right to then pay their percentage to the city. At least one of the artists is incorporated, and they pay their taxes to the state, et cetera. And so the only one that we seem to be struggling with is you guys.
Okay, any questions? All right. Thank you. All right, anyone else that's in favor of this application? Yes, ma'am. Your name and address, please.
My name is Chris Enzer, and my address is 2305 Government Street. And I just want to add that Central Presbyterian is really a community center, and the one thing that the artist forgot to mention was the urban garden that they have right there next to the parking lot, which also provides the food to the kitchen where they produce meals for the homeless and others. And the idea that they were ready to have their business license and pay their sales tax is great, and I'm really surprised that the home-based business license information wasn't provided, but maybe that's one of those you really need to talk about what is the objective at the time you make your application with the Board of Variance or Planning Commission. So that's what I have to say.
All right, thank you. Any questions? Art studio versus art gallery, what's the difference on the zoning again?
Well, an art studio is not specifically listed in the chart of permitted uses.
Okay, that's what she stated initially.
Right. So a photography studio is listed as a use that can occur in a B1 district with planning approval. Now, and that's for a portrait studio.
So if they painted a portrait, it would fit.
Well, you know, I have a little bit more knowledge of art as it relates to galleries versus studios based on some of my family history. And, you know, an artist studio is going to be a place where a person is producing works of art, whether it's going to be using photography, painting, or three-dimensional materials. And so that is something that can occur in a house, and they can get a home occupation license, but not everyone has room in their house to have a studio area. And so in this case, you have a facility that can provide a studio area, but they cannot sell their work if they want to do it through the legitimate license process of paying city and state taxes without getting this license. So it may be an oversight in our zoning ordinance, especially given the older part of the ordinance under the charter permitted uses versus like the downtown development district. So a gallery is going to be primarily sales only, not actual production of art.
So if they do studio function, but at some point somebody wishes to purchase an item, then that changes the classification. That may be something that...
Well, I mean, not completely. The primary purpose of a studio is to produce art. However, people will occasionally come by to the studio to purchase a specific piece of art or to look at what they have.
Okay.
Without saying you should approve or disapprove this, I will state that in the Haint Blue case, it's a very similar situation in where you granted a variance. It was appealed by the neighbor to circuit court, and the circuit judge agreed with our argument that the hardship was the fact that there was no category or classification in the zoning ordinance charter permitted uses for that particular use. Very similar here. Hers is an artist studio. There's no classification in our zoning ordinance for that. It's like a photography studio, which would be allowed. So that is support for variance if you are so inclined to vote that way.
Okay, thank you. All right, anyone else in favor of the application that has anything new to add? Anyone in opposition today? Okay, we have none for the record. Well, as Mr. Anderson stated, this kind of falls in line with a similar application that we approved, about a year ago, I guess. Something like that. Year and a half. All right, discussion, comments of the board?
Move for approval, Mr. Chairman.
Okay, I have a motion to approve, a second. Any conditions? Okay, I have a motion with a second. All those in favor of the motion say aye. Aye. Anyone opposed? Motion carries. Good luck to you. All right, application 6220, Scott Services, 4419 Range Line Road. they come to the podium, I just want to verify that we do not have anyone here at the moment from Rainbow Signs regarding the 1485 Satchel Page Drive. Okay. Your name and address, sir.
James Joyner, 5601 Brook Drive. I'm here on behalf of AT&T Wireless at 4419 Rangeline Road.
Okay, have you seen staff's recommendation?
I'm sorry?
Have you seen staff's recommendation?
I have not, no.
Okay, they recommend approval subject to some conditions. I'll give you a moment to look at them if they'll share that with you. As you're reviewing those, do we have anyone here in favor or opposition to this application? Okay, I just want to have time for them.
Okay, you said it was recommended for approval?
Subject to the staff's recommendations.
Okay.
The question, are you in agreement with those, or is the client in agreement with those recommendations?
Yes.
Or conditions, I should say. All right.
I just want to make clear that, you know, it's got existing building signs there, and the only thing that's changing is the font of the letters that are on the building currently. Just
Okay.
going from lowercase to uppercase.
So there's no new signs?
No change in the square footage of signage or anything.
It says that you're requesting 3 wall slats.
No, 2, front and rear elevation.
3 total.
Yeah, the description is incorrect. It's 2 on the building and 1 on the freestanding sign. And the reason for the variance is because they have an existing sign on the front of the building. They also have an existing sign on the back of the building. Under current regulations, they would not be allowed that second sign on the back of the building. Since they're just rebranding with new design, staff has recommended it for approval.
Okay. Are there any other tenant signs on the rear?
Yes, there are, and I think this site has come through the process before for some of the other tenants.
Okay. Just want to verify we wouldn't provide any disadvantage to the other tenants. All right. Staff recommends approval subject to the conditions listed. The applicant's rep has stated that they are in agreement. We have no one either in opposition or in favor of the application present. Chair will entertain a motion.
So move, Mr. Chair. Subject to staff recommendation.
I have a motion to approve subject staff recommendation.
Second.
Do I have a second?
Second.
I have a second. Any further discussion? All those in favor say aye.
Aye.
Anyone opposed? Motion carries. All right, thank you. Application 6221, Recording Williams, 7261, 7311 Airport Boulevard. Good afternoon. Your name and address, sir.
Yes, sir. My name is Keith Barrett, the general manager at Mullinex Ford. My physical home location is 12230 Jeff Hamilton Road. I'm here representing Mullinex Ford Lincoln and the owners, Larry and Jerry Mullinex, who reside and run businesses in Florida. Could not be present, but I'm the general manager at the location here.
Okay, now, staff recommends this application for approval subject to conditions as well. Have you seen those?
Yes, sir.
And are you in agreement as the representative?
Yes, sir.
Okay. All right. Any questions of the applicant by the board? All right. Anyone in the audience either in favor or opposition today? If you have anything to add, otherwise I'll give you the trip down here.
He's our engineer.
Okay.
He's the gentleman that's less of a recording.
All right. And like you stated, you're in agreement with
Yes,
this. For staff, this is a substantial number of signs, but this is kind of a spread out property based on all the buildings and structures.
Well, it is a very large property. It is a large number of signs as well. They are doing a significant amount of work on the property. They're building a new building on the site, and they'll be changing some of the layout on the property in terms of inventory as well as customer parking. The fact that they are doing more than one Ford product, so they're having their Ford automobiles as well as Lincoln. In other cases, the board has ruled or been sympathetic to other auto dealers where they have certain requirements from corporate to have either a separate freestanding sign for a separate brand or to have additional signage above and beyond what would normally be allowed.
Okay. All right. Any questions of the board for the applicant? All right, staff recommends approval subject to the conditions as noted. The applicant is in agreement. We have one in opposition here today. Chair will entertain a motion.
So moved, Mr. Chair. Subject to staff recommendation.
I have a motion to approve subject to staff recommendation. Do I have a second?
Second.
I have a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Okay, motion carries. Thank you.
Thank you.
All right, application 6221, Sheridan. Yes. Is this the next one? Yeah. Yeah, 6221, or, yeah, 2, I should say. And just for the board again, there's files here. If anyone wishes to see a file, please let me know. All right, your name and address, sir.
Steve Sheridan, 201 Ridgewood Place. Mr. Chairman, I'd like to remove item number 5 from the agenda.
Okay, you're requesting that we remove it?
Yes, sir.
Okay. Well, therefore, we have no more business regarding this one. Thank you for your time.
I guess I didn't need that.
I'm sorry you had so long to tell us that, sir.
I've got another one coming up.
Oh, okay. All right, and we've heard 6 and 7 discussion quite depth. Let's see here. Applicant 6225, 6149, 1590. This is 5701 Old Shell Road. And we've already had at least one variance on this property that I can remember.
All right. You already had one variance?
Your name and address, sir.
James Gabbard, and I'm representing Zito Russell Architects for 180, 181.
All right,
LLC.
yours is recommended for denial. Would you tell us why we ought to consider otherwise?
Yes, sir. The staff recommendations noted that we have angled parking that could be turned into 90-degree parking, in which would accommodate some additional spaces. I'd like to point out that angled parking can be done on a one-way drive. We have a drive-through on the site. Two-way parking usually requires 90-degree parking and 24-foot setback. If we were to put a two-way drive in the site and restripe it as recommended, we would be creating a hazardous condition in which someone to go into a drive would have to go through oncoming traffic. So for that point, I think I would disagree with the city that changing the striping to 90-degree would not be feasible on this site. They mentioned a couple of other points. One of the points that they agreed with was the electrical switchgear on the site. We've got a large transformer that was not intended to originally be on our site. It's supposed to be on the adjacent site. Due to keeping one of the oak trees on the corner, that was relocated to our site in coordination. And that's kind of one of the basis that we're asking for a 2-car variance for today, is basically if that transformer was not there, we would be able to put the additional cars that we needed, and we would be able to accommodate this tenant that we're trying to accommodate.
Okay. The other comment was regarding a dumpster. Does AT&T utilize a dumpster?
AT&T utilizes dumpster. Now, the health department's stance on that, if I'm not mistaken, is if a future restaurant was to come in here, specifically the ice cream shop was to come in here, if the ice cream shop was to manage dumpster waste disposal and the grease trap, then the health department would not allow the tenants to share the dumpster. However, the landlord is willing to take over the management of that dumpster and that grease trap, in which case multiple tenants can share it. Okay. We've done this at several shopping centers in town, and so.
Okay, any questions of the board for the applicant? All right, anyone in the audience either in favor or opposition to this application today? All right, I can tell you I visit this area quite frequently, and as you stated, it is quite congested with the current flow of traffic. If you were to change it, I'm not sure it would be safer, but
well, and I think any car coming across to happen to cut across an adjacent lane to go into drive-through, you know, you could be possibly blocking traffic, and I disagree with that specific.
Well, and I think you stated the hardship is that this electrical transformer created an unexpected hardship that now you have less space to work with from a
Yes,
site
sir.
plan.
Basically, if we didn't have that there, then we have put 2 more parking spaces and wouldn't need a variance.
Okay. All right. Any questions of the board, comments? Staff?
I would like to say that we did con the Mobile County Health Department about the dumpster issue, and they said that they normally don't encourage dumpster sharing, but they do have the provision where it can occur. So if they are not required to have a 4th dumpster, then they would only be the 2 parking spaces short. And I'd also like to point out that the southern portion of the site here, I think, is within the floodway for 12 Mile Creek, so they really can't expand any of the parking lot area to the south because of the existing creek floodway.
Okay, thank you. All right.
Move for approval, Mr. Chair.
I have a motion to approve.
Second.
I have a second. Any further discussion? All those in favor of the motion say
Aye.
aye. Anyone opposed? Motion carries. Thank you for your, for your time. All right. Let me make sure I'm... Okay, 6226. This is 259 Cherokee Street. Your name and address, sir?
My name is Keith Nisley. I live at 1058 Hillcrest Road, Hillcrest Lane, excuse me.
Okay.
The property in Creston is 259 Cherokee.
Okay, and your application is recommended for denial. You want to tell us why we ought to think other or consider otherwise?
Absolutely. So about 2 months ago, I bought this piece of property. It was marketed as a 4-plex. I was hesitant about it. I went out and looked at it. I was hesitant because a lot of properties advertise that it could be converted to a duplex or 4-plex, but those typically, they're not financially feasible to do such because of plumbing and electrical. So I went to look at this piece of property, and the first thing that I noticed was that it did have 4 separate electrical boxes, 4 separate services, electrical services. So upon my investigating, I talked to the power company, and they told me that it had 4 separate services. So I proceeded to purchase this piece of property, excuse me, under the assumption that it was in fact a 4-plex. Once I discovered the zoning issue, that it had lost its multi-family status and had been zoned as a single-family unit. I looked at the options of what I could do with that, and it's not feasible to do anything with it as a single-family dwelling. I don't think that I could sell it. If I invested the money to fix it up, I would just barely be able to get my money back out of it. It would probably take $120,000 to $150,000 in renovations. I would probably be able to sell it for that price. So there would be no equity in that for me. I could not rent it as a single-family dwelling. Anyone who could afford a 2,800 square foot house in Midtown probably could not afford the utilities on it, and they would probably choose to buy a newer house out in West Mobile for that price. So the only other option that I would have, if you guys decided to deny my request, I would have to sell this, excuse me, I'd have to wind up selling this piece of property, which is probably why it's set on market for 10 years, because no one can do anything with it as a single-family dwelling. If I were to put it back on the market, it would continue to be a target for vagrants. It would be a nuisance, it would be a hazard to the children in the neighborhood, and it would continue to be an eyesore. If you have the photographs, there's a sign in the front yard that says no dumping, and I'm sure it was put there on purpose because it was a dump, literally. So You guys have the opportunity today to improve this and improve the neighborhood. It would be not only a source of revenue for the city of Mobile, it would also protect that neighborhood and beautify it. Not only would it not only would it be an impact on the city of Mobile as a liability for it to continue to sit vacant, it would also create a hardship on me and my family, as we were under the impression that this was in fact a fourplex when we purchased it, because it is physically set up as a plex.
Okay, couple questions. You stated it had 4 previous electrical connections. Has the property at some point in the last, since it lost non-conforming use, had it ever been converted back to a single-family residence?
No, sir.
So there's still a separation between each of the units?
That is correct.
With separate entrances?
That is correct.
Okay. How about parking? Was there one common drive area, parking area?
There is one, there's one way, and there's a large area in the back that was used as parking. I believe that at one time it was paved, but again, that property is vacant for 10 years. So I do see evidence of pavement, but it's covered under by soil. Okay. But that was obviously the parking area. There was a parking light, a city street light illuminating that parking area.
Okay. Question for staff. This lost non-conforming use when?
Well, as noted in the staff report, there was a note in our permitting system, I think, that said in 2008 it had been converted into, I think, a single-family residence. Because the structure had been vacant for more than 2 years, with any apparent attempt to reuse it as a fourplex or any sort of multi-unit, it would have lost its non-conforming. So if it's been sitting on the market for 10 years and there hasn't been any attempt to maintain it as a multi-family development, then we would have considered it having lost its status.
Okay. All right. Any quick question of the board for the applicant?
Yes, sir, Mr. Chair.
Yes, Mr. Metcalf.
About how much are you, would you be spending on the property to bring it back to a fourplex?
About $100 to $110 is my estimate.
And would you mind asking what you for it?
24,000.
Okay. And what are your rent structure? What do you think you'd rent each unit for?
Altogether, it's going to be around $2,400.
For the 4?
For the 4, yes.
Okay.
Each one is a different size, so that they're not all the same rent.
Okay, thank you.
Okay. Sure. Any other questions? Yes. Mr. Coleman.
What's the time frame that you expect it to
have it finished?
Yes.
6 months would be the longest.
What are you planning to do to bring it up to code?
What am I planning on doing to bring it up to code?
Yeah. What do you plan on?
Okay, it needs a new roof. I'm planning to completely redo all the kitchens, new cabinets, new granite countertops. I'm going to redo all the hardwood floors. The bathrooms will have new ceramic tile that I would like to go with the time frame to make it look time era appropriate. The new HVAC unit, there's never been an HVAC system in the house, so each unit would have its own separate HVAC system.
What about the exterior?
The exterior is actually aluminum siding, so it's in fantastic shape, so it would be pressure washed, caulked, and painted.
I live right around the corner from this. I'm interested in what you're going to do.
Okay.
Is it
a nuisance?
Mr. Coleman, do you ever remember it being a multifamily?
No, I don't remember. I don't remember anybody being in it. And it's been trying to find who for the last 10 to 12 years. Nobody could find who owned it.
Well, and that's a good point. If I'm not able to do anything with it, I don't foresee anyone else being able to do anything with it, and it will continue to sit there and fall apart. And it's really a shame because of the roof leaks that it has right now. In spite of the roof leaks that it has, it really is in pretty good shape. I mean, structurally. I mean, it's got good bones. But if something is not done to it quickly and immediately, it will deteriorate rapidly.
I agree with you.
Okay, any further questions?
I'd just like to make a comment,
Yes.
Mr. Chairman.
But-
Mr. Nisley, I think just a comment I'd like to make, similar to the application that was previous of 2200, you know, we can't really make economic decisions when, you know, that's not part of the purview of what we're supposed to consider. We're supposed to consider, you know, is there a, you know, a hardship on the property that would not allow it to be used as a residential, single-family residential as it's currently
Okay.
zoned. So, you know, the fact that, you know, you bought it and financially it may be, we're not, you know, that's not to factor into our decision. I just want to make that clear to you. Thank you.
Okay, do we have anyone else in the audience that's in favor of the application today? Anyone in opposition? Okay, one at a time, if you will, come down here. Sir, you have a seat, please. Your name and address, please.
Johnny Weaver. I live at 262 Cherokee Street. I'm also going to be speaking on behalf of Mr. Joey Pittman, who actually owns 4 properties on the block, 255, 252, 257, and 261, along with my neighbor, Ms. Powell, who lives at 260, and everyone else on the block. I've lived there 15 years across the street. Most of what the gentleman has said is actually incorrect information. The house has sat vacant, but only because there was no clear deed. When the property had a single family in it in 2008, they were actually squatters, because the owner was from Texas. Though he died, and his wife had no idea that he even owned this piece of property. It fell back to the bank. So the squatters were they started out paying rent to the female in Texas, but then they stopped paying rent. So this is Miss Kravitz, actually is her nickname, my next door neighbor. She knows everything that happens on the street. So right. So she was actually the person responsible for getting the city out to get the squatters out of the home. It has sat vacant. We have been concerned about it. You know, students, we're constantly making sure that it's a safe place. We keep it clean. We clean up our street from Government Street past LaSalle to the train track. I would like to say that, you know, I live in W.P. Davidson's original home. He built it in 1921. I bought it because I was an educator, and his family wanted me to live there. We're very near to being able to be a historic neighborhood. We're supposed to be adopted into the Linecoff district all the way to DIP, which is the next door. Having another apartment complex back in the neighborhood would not be beneficial to my property, not to the value of my home, not to the historic value of the neighborhood. We already have one fourplex on the block. Parking is horrendous. So when they have visitors over, they're parking on the streets, people trying to get through. We have people that have their side mirrors knocked off. It's just not a place for a fourplex. It's not big enough, the property, the parking. I'm sorry that this gentleman bought it, but it was under my understanding, and it's only been on the market for just a few months. Just acquired it. You know, the sign just went up. There's been numerous people looking at the property. There was several offers on the property. If the property had stayed there, single family, there was tons of single families looking for property of that value to be able to put $100,000 into to live in. Mr. Pittman, all his properties that he's renovated on the street, they're all rented to families. And we want it to remain a family neighborhood. I love it there. And we don't need an apartment. It's R1, and it's R1 for a reason. If you have any questions, I'll be happy to entertain.
Any questions?
Yes. Is this a normal single-family residential lot?
Yes,
It's
originally.
basically a normal lot.
Normal lot, one driveway, single in. My yard's a lot bigger than in the back, but to park 4 apartment cars back there, they have visitors over, you can see that how narrow the lots are. There would be no way for more than 2 cars to park on the street.
Go back to where it shows the neighborhood.
We no longer receive our mail to the front door.
There you go.
There it is right there. It's
50 by 150, I think.
right. It's just not enough park. I mean, when the cars start parking on the street, it's even hard to turn into your own driveways. We can't receive our mail anytime people are parked in front of our mailbox. They will not get out and give us our mail. There's several days that we don't get our mail if people are parked on the streets. It's just it's a nuisance.
Okay, any other questions? All right. Anyone else has comments? Ms. Kravitz? Good afternoon. Your name and address, please.
Paula Powell, 226 Cherokee Street, and I lived there since 1973. And I think he sees me out clean from Government Street all the way. And like I say, they call me Miss Crabbit. Everything in the neighborhood, I'm going to know about it. I'm up all the time.
I always like neighbors like you.
Yes, yes. But Mr. Weaver said pretty much. And to me, Mr. Keith, if I'm not mistaken, I was cleaning up the yard when he come over and talked about it. And I told him, when I talked to Fannie Mae, the people that came out, they said they were going to condemn it. So it was a surprise to me to see him saying he had bought it. And I had talked about it, and you know, and I was trying to advise him not to, because the roof and all, people done stole all the plumbing out. You can see all the way through on the bottom and everything. And, you know, even though the value of my house have gone down, but I would love for something to be there, because they did have vacancies in there, and we've had, when I moved out there in 73, 74, somebody got killed there. The house been set on set fire to it, not the whole house, but apartment. But it's just so much been going on over there, you know.
Have you ever seen more than 2 families live at that residence?
No, when I moved there, it was only one set. Okay, like Mr. Weaver was saying, at one time, the hardest, that's what I call them, they had moved in 4 elder ladies, and they were walking the neighborhood at night, and that's how the 4 meters got up there. I couldn't understand how could they have gotten license and everything to do that when they wanted to run the extension cord from my house to there to get electricity. You know, she said until they get their lights on. So I was asking, how did y'all do this? Where did these people stand? And come to find out, they were coming asking us for food, because they were paying whoever the person was money to stay there, but they wouldn't get any food or anything. So I called the city about it, and the next 2 days they was out. However that came about, no.
So that's when the 4 meters were installed?
Yes, the only time.
Okay.
Yes.
Have you ever been in the house when it was in good condition?
Yeah, it was gorgeous. I mean, it looked like back in the Western days with the stairs curving round. But I mean, we've had people's all kind of activity.
So when you were in there was 1 family?
Yes,
okay.
yes.
Okay. Any questions of the board?
Yeah, Mr. Chairman. So,
yes.
Ms. Kravitz, was it? That's
Ms.
what
Powell,
you said
right?
your name was.
That's fine. That's fine.
Okay. I should have gone by and looked at it, and I didn't have a chance to. I'm sorry, but it was obviously built as a single-family
Yes, it
residence.
was.
Is that correct?
Yes, it was.
Okay. And since you've been there, it has been used and occupied by a single family.
Yes, only for about a couple of months, and I don't know how they got that done. That's the reason why I called the city on them.
But so since you've been there, no one has really used it. Is that what you're saying?
No, not livable.
Since 1973?
No, not livable. You know, they like have the one set in, and like I said, that the time the guy got killed. And I think that's when they shut it down, something then, along that time.
Okay,
he got killed on the back step.
Question for the staff. Is this a condemnable structure? Have y'all been out there? Have y'all had complaints and looked at it from a safety or?
That would have been something that municipal enforcement would have had to have done, and we did not check those records.
Okay, so you don't know that there's been any, the neighbors have called or anything?
We can check and see, what the complaints have been and any damage assessments have been done.
Okay.
Okay.
Sir, hold on. You have to go to the podium if you're going to make a statement.
To answer your question, sir, the same week that the city came out and spoke to Ms. Powell about condemning the property, that's the same week the bank took ownership of the property again. And they put a for sale sign the very next day.
Okay, Ms. Powell, you called the city?
Oh, yes.
And then what did the city officials tell you when they came out?
When they said, to my knowledge, they saying no one's supposed to be in there, is supposed to be condemned.
Well, no. I'm concerned specifically about the condemnation. Did they tell you that they were going to condemn it?
The one that had Fannie Mae, that came out with the key to go in, that's the one told me they was.
Oh, well, that was with Fannie Mae. That was not with the city.
I'm thinking that's.
No, I understand. I understand. But you said the city came out.
That was the city.
Yes, that came out saying that they were going to condemn it. When the guy came in with the key to go in, he said that Fannie Mae, you know, he was opening it up to go in for Fannie Mae or something like that. I'm not quite sure, but when the city did come out, that's when the people were staying there illegally. Okay. You know, they ain't supposed to be staying there.
Okay. I'm sorry to keep asking questions, but I should have seen it. Is the exterior of from your opinion, is the exterior of the property, does it have the presence of a single-family home?
From the front, yes.
Yes.
Oh, yes.
Okay. All right, thank you.
Oh.
Okay. All right, anyone else that wishes to speak in opposition? Okay. Sir, do you have anything, as the applicant, anything to say in response? You don't have to come down. I've just given you the opportunity.
Wow, thank you. I think you had mentioned the nuisance complaint that was in fact cleared up. I did call the city, and they released that, so that has been cleared up. I just wanted to appeal to this council one final time that I honestly do not feel that anyone else, any type of investor or homeowner, would come by and be willing to invest this kind of money into renovating this house. So I am all for building the community and building up the and having it join the Historic Society and the Lioncoff District. This piece of property is still going to be an issue, and without moving forward with this, it will be a liability, and it will be dangerous to the children and the people in the neighborhood. It's going to be a hindrance either way. Just no one else is going to buy this piece of property for a resale, flip, or to live in. It's just not feasible. At this point in the history of this neighborhood, a multiplex is the only thing that makes sense, in my opinion. So I hope that you would do the right thing and help me to improve this neighborhood and bring some revenue to the city.
You mentioned, of course, we got conflicting statements or opinions. 4 meters, 4 kitchens?
Yes.
Already in this facility?
Yes, there are 3 kitchens there. One of them has been gutted, so there's the evidence of a kitchen there.
So there was, at some point, somebody has modified it to make it into...
Yes.
Okay. All right, that's all I have.
Yeah, 4 bathrooms, 4 kitchens, yes.
That's coming, Mr. Chair.
Yes, Mr. Coleman.
You're saying there's nothing that improves the neighborhood. I disagree with you. The house right down the corner from right behind the law office, my son lived there. I personally really helped the house. And it's sold for big time money. But my son, he moved out to West Mobile. The house right next door to it is being remodeled, has been remodeled in the last month. And the family moved in. 2 doors down on the other side of the house, the people are remodeling that. So to say that the neighborhood and on one around the corner on Government Street just being remodeled now. So there's a lot of remodeling going on in that neighborhood. So I think that if you were to do for a single family home that you're doing for folks, you'll get your money back in big time. No money. You just have to be committed to doing what's right for the neighborhood and help the neighborhood in order to improve it. I don't think you'll lose any money. Somebody will buy it if you do it right.
Okay. Thank you, sir.
Okay, thank you.
Mr. Chairman, one more question for staff.
Yes.
Let's say that nothing happens to it. Is it in a condition, or may soon be in a condition, that they could face condemnation? And then what would happen then? Is that something that the city would tear down, or require to tear down, or?
The city would notify the property owner to stabilize the structure, and if the property owner doesn't follow through with that, then they would be taken to environmental court, and the judge could request or require action be taken by the property owner. And
action meaning keeping it from leaking?
Well, keeping the windows boarded up, keeping the roof secure so it doesn't leak.
Okay.
There's nothing that the city can do to require the property to be renovated.
I understand.
So
but how about torn down?
It would depend on how bad the property is. There's a possibility that a municipal enforcement officer could inspect it and determine that it is a hazard and needs to be torn down. But I don't know that it would be a cost that the city would necessarily incur. If the city were to do it, they would then, I think, put a lien against the property.
Right.
Yeah, usually the city council is given a list of properties that are to be condemned and demolished, and they review that and approve it, and the contract gets sent out, and then the lien gets placed.
If this area were taken into Linecoff, would that change anything?
It would increase the review as it relates to renovating the exterior of the...
But that's all?
Yes.
Okay, thank you.
All right, any further questions of the board? All right, I think that concludes our comment period. Staff recommends for denial on the basis that it's lost its non-conforming use. We've obviously heard from the neighborhood that they're in opposition. Okay, any further discussion of the board? Chair, entertain a motion.
I move for denial.
I have a motion to deny. Do I have a second?
Second.
I have a second. Any further discussion? All those in favor of the motion say aye.
Aye.
Anyone opposed? Opposed? Okay, motion carries. Who was opposed, please?
I did.
We have 5 to affirm the motion, 1 to deny. In opposition, I should say. All right, if you have questions, sir, if you'll get with staff later and they'll explain to you your options. Okay, thank you. All right, we're on application 6227. This is 308 Glenwood Street.
Okay. All right. I think that there's somebody about that.
Good afternoon. Name and address, please.
Donna
United
Pierce,
Noodles.
308.
Got to pull the mic closer.
Donna Pierce, 308 Glenwood Street.
Okay, and your request is for off-site parking use and surface variance for an automobile dealership office in a B2, and it's recommended for denial. You want to tell us why we got to consider otherwise?
Yes, sir. We understand that it's a B2, and we want it to continue to be a B2 zoned property. I have owned the property since 2013, roughly, and it actually, for me to request to put a used automobile dealership in Midtown on Glenwood Street would be hard. What I really would like to do is to have the opportunity to utilize my current business office as an office for the automobile business. We have a storage facility off-site in Daphne where the cars are kept because of the flooding issues and all the other things, and just our general respect for our neighbors on Glenwood Street. We would never impose a used automobile dealership on Glenwood Street.
So you're asking for this to be an office?
Just an office. All
Okay.
I want to be able.
Is it currently an office?
Currently, yes. Currently, I run Prestige Partners out of there, and we have a tenant, Tammy Wynn with Spring Nails, who utilizes the front office for her clientele. And, I mean, it just is it's strictly a business office, and that's...
So, let me ask staff something. I hate to cut you off, but
Sure.
why are we having, if it's strictly a use?
Well, specifically relating to auto sales, we have historically had problems with other people wanting to do this. They base it out of their house or an apartment or in a B2 site where auto sales is not technically allowed. An office would be, but what ends up happening is that cars will start to appear for sale at that location, or people might do the auto auction aspect of it, and they'll go get a car, pick it up at the auto auction site, and it'll end up at their house or property prior to it getting to the new owner. And so to be consistent we recommended to Pierce that we could not approve the request due to the fact of other people, not necessarily the Pierces, having historically had cars showing up at the location when it's not rezoned for car sales. So that's why they're here before you today.
Okay, so back to my original question. If this was just to remain in office, they wouldn't have to get a use, and the parking's variance and all the other.
Well, the other variances requested are just to clean up this property in that they have the adjacent lot next door where they are actually providing parking for customers that they currently have people who work there. So other than the use to allow an auto sales office at this location, everything else is just to clean up this site.
And if I could interject one error in my kindergarten drawing up there on the screen, that parking lot is actually an asphalt parking lot. It is not a gravel parking lot. The only thing gravel on the property is the gravel driveway that you see over here next to the mailbox. And Glenwood floods so rapidly that it deteriorates the driveway as fast as we can repair it. And it is one of the worst flooded properties on the street. We suffer from that every time we have a rainstorm. So our intention is, it would be detrimental to us to ever store or park a Highline vehicle on that property. We simply want to be able to do our paperwork from that office location, just like I do for my insurance firm and just like Tammy does with her clientele.
What's the property zone, Des? So it is B2, and an office would be acceptable.
Yeah.
Only.
There would never, ever be a car on that property for sale.
But you're trying to handle the transactions.
I just want to keep my paperwork and my files in the same place I always keep my other stuff. Just from a simplicity standpoint.
Mr. Chairman?
Yes.
Did it really kind of come to light because of the nature of the business being automobile sales?
Yes, I believe it came
because
to
of a
light
business permit?
when you were coming to get a business license for it.
So there's really no distinction between the office, automobile sales. From the city's perspective, that's everything. That's selling them and showing them.
Well, again, historically, it's been office for auto sales, office only.
Right.
But we've had this problem of cars start showing
that
up.
they start to. Yeah. So basically what you are trying to do is to make sure you don't have a problem with her having her office there. You just don't want to make sure that there's no cars going to be there.
I would be.
Can we you don't want to say it? Yes, we can restrict it.
I would be happy to sign anything.
Yeah. Okay. That's
that
probably the
would
way it's going to go.
restrict that.
Okay.
Mr. Chairman, I
Yes, Mr.
have
Miller.
a question for the applicant. I drove by there this morning. There is a car on that lot with a tarp on it. What is that?
It's an antique Saab that will be moved to our warehouse in Daft in the next week. It's been there for quite some time.
Is it for sale or is it just?
No, it's mine actually. I have a love for antique Saabs, and it is like a 1980s convertible that will be restored.
Okay, yeah, I think it's listed in the staff's notes.
It's drawn on my drawing.
Yeah, I seen it on, that's what it was. I seen it on your drawing. Okay. Any
Ma'am,
other
if
questions?
1980s is an antique, what am I?
A classic.
Any car over 25 years old can be listed as an antique.
Not to me. You would be called historic. All right. Anyone in the audience that wishes to speak either in favor or opposition to this application? Do you have anything to add? If you are, come give us your name. Okay.
What I'd like to add is, in
Name and
addition,
address.
oh, yeah, that's right. I'm back again. It's Enzer, 2305 Government Street. What I'd like to add is, when she talked about the flooding, I don't know if any of you ever drive on Glenwood, but 1 inch of rain will go over the curb at her driveway, both of them. She actually brought some pictures of the last 2-inch rain that we had just about a week and a half ago that has the pine straw line all the way, like within 5 feet of her front door. So, an office only, that business location has been that style of business, or it was a CC salon before Ms. Pierce purchased the property. Glenwood is a very neighborly street for business and residential neighborhood, and there's residents right behind and to the south. And so Ms. Pierce guarantees that you grant her this use and grant her the variance for messing with the parking lot. We don't want to disturb any ground there because the trees are all that's holding that ground there and that blockage in the sewer. So anyway, we need her to get her variance with her condition that her use is office only and no cars, maybe not even her antique Saab.
Antique Saab. It's going to the warehouse.
All right.
Too.
Okay. Anyone in the audience in opposition? Okay, we have none. All right, questions of the board?
I have one, Bill.
Yes, Mr. Miller.
Bert, has there been any opposition to this that you've seen?
I think it's just been the staff concern that has been the main issue.
Okay,
so.
thanks.
The forestry guy's left on me. I was going to ask him how the tree planting is in this area. That would discourage parking in areas that were, of course, with the flooding, I don't know that anything revived, possibly.
Well, we know from other auto dealerships that they do not wish to park inventory underneath trees. So if the parking area has trees, she would obviously not be to put cars there that she would want to sell. So.
It's covered with trees.
Yeah, yeah.
Well, I'm thinking of the front areas. Site plan again. It looks like it's heavily covered with trees, so.
It is. There would not ever be a Highline Mercedes or BMW parked on that property.
That's right. That's the speaking question.
If I may, there was one other thing. That section of Glenwood and all the way down to Holcomb Avenue is scheduled for rebuild and paving. It's on the 2019 ZIP project list for redesign, for design and rehab. So that's also a coming thing. They've already started to mess with gutters here and there, and I'm certain they're going to be working on the street and the stormwater at the same time when they start to work on that.
Okay, thank you. Any comments, questions of the board? I know from experience, like the staff, that we've allowed other auto sales type facilities to use a small parcel, and they move to the east and to the street actually with some of their inventory. If I could think of a way to discourage it other than planting a few trees, I don't know of anything else. Chair, entertain a motion.
Mr. Chairman?
Yes.
I move that we approve the application with the condition, specific condition, that it be used only for the clerical and office operations, and that there will be no display, storing, or sales of any vehicles other than their own employees and principals' personal vehicles.
Second.
Okay, a motion with a second with the conditions. Any further discussion? All those in the motion say aye.
Aye.
Anyone opposed? Motion carries.
Thank you.
Good luck to you.
Thank you.
All right, application 6228, they have requested withdrawal, so we can skip that one.
Right.
And then we are at 6229. This is 3961 Spring Hill Avenue.
Yes, Mr. Steve Sheridan again.
Yes. And this particular one has kind of got a mixed response from the staff. Denial of the access maneuvering, but approval of the tree plant, landscape, and residential buffer. Have you seen that?
Yes.
Staff? Okay. And so you want to tell us why we ought to consider the access maneuvering?
Yeah, absolutely. William Latta, Clark Gear Latham and Associates, 3901 Spring Hill Avenue. Yeah, we're here to discuss the recommendation for denial of the access and maneuvering. This variance is being requested to allow a 14-foot drive in between the building and the property line, which would allow the applicant access to a proposed storage building that would be located to the rear of the existing office. The drive is constrained in width by the building and the property line, and thus is limited to the 14 feet as shown on the site plan. The staff report states that a pre-development meeting was held prior to the submission of the two-lot subdivision, and that staff had made recommendations to avoid the need for variance. It also states that staff advised the applicant that they would not be likely to recommend access and maneuvering variance for approval due to it being a self-imposed hardship. The report states that after being advised by the staff, the applicant chose to disregard and not adhere to the staff recommendations. The staff report is accurate in stating a pre-development meeting was held. However, a few points of clarification about what is written in the report need to be made. The pre-development meeting was not held prior to the submission of the two-lot subdivision to the Planning Commission. It was held the day of the Planning Commission meeting, and thus would have required altering the property lines at the meeting and possibly requiring a holdover or a withdrawal and resubmission of the subdivision plat. At the pre-development meeting, the staff did inquire about potentially altering the property lines of the subdivision to provide more width for the drive aisle. However, explained to the planners that different entities controlled the properties and that these were the negotiated dimensions. It was not as simple as just being able to change the property dimensions. One thing to note is that the subdivision did not reduce the width of the property, thus impose this restriction on the drive aisle. It was actually widened slightly. While the staff did initially indicate that they were likely going to recommend that the access and maneuvering variance for denial, the applicant wanted to discuss some potential solutions that staff could support. Upon hearing staff's concern regarding public access, the applicant inquired about providing a fence and a gate, which had not originally been included on the site plan to eliminate public access to the proposed drive. The applicant explained that the drive was not intended for public use, that it was more akin to a loading zone for the storage building. And upon considering the addition of the gate, the planning staff indicated that they could potentially support the variance. The applicant made every effort to work with the staff regarding this variance, and every indication was that an agreeable solution was found. The idea that the applicant just simply disregarded the staff's advice and just went away with it is incorrect. No indication was made by the planning staff that they would no longer support the variance with the addition of the gated access since that meeting up until the staff report was published Friday afternoon. Furthermore, there has also been precedent in the local surrounding area for this board approving narrower drive aisles. Less than 400 feet away, a variance was approved to allow a 16-foot wide driveway for a retail and office building. That driveway was the main access from the street, whereas the applicant's plan is just a private access drive, not connected to the street and not intended to be used by the public. As such, traffic engineering, who reviews sites for circulation and access, has no objections to the applicant's proposal. To close, in considering these facts, we believe that there are certainly conditions that pose a hardship and that approving this would not be contrary to public interest. We ask that you approve the variance along with others.
Okay, question. The existing building, your dwelling, is utilized for what now?
An office.
Okay, and what will the proposed storage building be utilized for?
Storage for the office, for their office uses.
Okay, I mean, it's a fairly sizable facility, 2,300 square feet. I'm trying to see what the square footage is of the office.
You may need to speak up due to the air conditioning as well.
How many occupants are in the office complex? You got to come to the podium, sir. I'm sorry. And you know the formality. Name and address.
Steve Sheridan, 201 Ridgewood Place. My office houses myself and my son and my wife's interior design business. This is used for storage, so if I have some ply left over on a job from building a house, if I have some tile left over, I plan on putting it back in the warehouse storage garage. I might even park a car inside the garage. It's a metal building with 3 garage doors on it. There's no plumbing. It's enough lighting to see there. That's it.
So
it's on a slab.
Will it in any way be a public access?
There's no public access. You have to come in my parking lot, come down that 10 or 12-foot driveway to get to the back to get to it, and I'm going to gate it.
My question is, are you going to allow the public to go to your storage facility to look at the remnant stock or whatever you want to call it?
I don't intend to, no.
Okay. Okay. Any questions of the board for the applicant? Okay, thank you.
Thank you.
Because this is a business that requires the wider drive, not because of a...
Well, the variance that I think was mentioned by Mr. Lotta for the site is for the Quinelli property to the east on McGregor that was being developed under the Village of Spring Hill regulations. The driveway there was too narrow, and that's why they made their variance request for that. For this site, though, the Quinelli property, when it came through, wasn't dealing with a subdivision of land as well, so there was no change in property boundaries at that time. This site, the plat that was approved by the Planning Commission to create a legal lot for Mr. Sheridan to expand and build this new storage in the back, still hasn't been recorded. So staff is of the opinion that there is still an opportunity to adjust the location of the property line between the 2 lots to have this access variance requirement.
Can I address that?
Yes. Any questions for staff before Mr. Sheridan speaks? Okay, Mr. Sheridan, please.
The adjustment of the property line that he's speaking is owned by another entity. They agreed to sell me the 10 feet that I did to make that subdivision. There is no more land available to expand that way to make the driveway 24 feet or whatever that requirement is. This is not a two-way driveway to get back there. We're not having cars pass each other. If we have something to stick in the warehouse, we're going to go back there in the warehouse and come back out. I agreed to put a gate from the side of my existing office to the property line. That'll be a gate with a padlock on it or some sort of a lock to where you know nobody's going back there but me. It's strictly a storage building.
Mr. Chairman?
Yes.
Why is it a separate lot, Steve?
It's not a separate lot. There's a big piece of property to my west, and they owned behind my building where the warehouse is to be located, and so I bought that and the extra 10 feet to make the lot behind my building as part of my lot. That's lot number 2 now.
Okay, so they're doing a 1-lot sub.
That's correct.
No,
it's 2-lot subdivision.
It was, the subdivision was this entire blue area, and Mr. Sheridan's property ended right here.
Yes.
So he's acquiring the rest of this and a little bit.
But for 1 lot.
For his 1 lot.
All right, and then why is there a PUD involved if there's 2 buildings?
Because it is storage. And the PUD it's an accessory.
Okay.
And the PUD was amended to allow this.
Okay, gotcha.
Okay, any further questions? All right, anyone in the audience either in opposition or in favor that has anything to add? All right, we have none for the record. Well, staff recommended denial of the access maneuvering, but recommended approval of the tree planting, landscape, and residential buffer request. I'm not necessarily sure I see, other than buying additional property to the west, that he can undo the hardship of the property line. But you say it has not been recorded as such yet.
Oh, when I was reviewing the staff reports a week ago, it hadn't been at that time.
Okay. But as far as the plans that have been submitted to us, site plan, that's the boundaries, correct?
The boundary as shown here matches what was proposed for the Planning Commission to approve.
Okay, so the 14-foot is the maximum width of the driveway as these plans?
Well, what the Planning Commission saw was only the division of land. It did not see any proposed development.
I'm talking about what we see today.
The 14 feet is what they're requesting.
Yeah.
I'm not sure if fire department have any access requirements to the back. They may not.
20,
But if it's a storage building and if it's not combustible, they may not be required to have truck access to the back.
Okay. All right, any other questions of the board? Discussion? Chair, entertain a motion.
I move approval.
I have a motion to approve. Do I have a second?
Second.
Second. Any further discussion? All those in favor say aye.
Aye.
Aye. Anyone opposed? Motion carries. All right, I think we
Mr.
are-
Chairman, can we note for the record that since I've been on this board, we've never gone past 5?
Yes, and I would agree.
Took that other one out.
That's right.
All right. Do we have any other business for the record?
I'll just note that for item number 1, which is for the signage in McGowan Park, I think the sign contractor is from out of town, and we haven't heard anything from them regarding making an application to amend the PUD sign package. So we can either, the board can either vote to hold it over again, or the board can vote to deny the request.
Let's hold it over.
Okay, I have a motion to hold it over.
Yes, that's my motion.
Do I have a second? For what length of time?
Yeah, the next meeting.
30 days?
Yes.
Okay, I have a motion to hold it over 30 days and a second. Any further discussion? All those in favor of the motion say aye. Aye. Anyone opposed? Motion carries. Any other business?
No, sir.
All right, we are adjourned. Mayor?